indictment here and the statutes under which it's charged upon just within the four corners of the complaint. Again, we're going to accept everything in there that they say is true, but even when we're accepting everything that they say in there is true, it doesn't reach up to these, and they are broad principles.
But just so I'm clear what lane we're in, though.
Yes.
The argument isn't like many of these cases that we read about in the establishes principles that the fraud statute has to go away. It's as applied here. It's unconstitutional, right?
It's as applied here is unconstitutional, yes.
But we have to get over that first hurdle of whether we can make an as-applied challenge, which I think that you've pointed out some case law we didn't consider the first go-around. And
I think that some of these statutes can be attacked facially, but yes, it's as applied here.
Okay, well, maybe we should start there then. What statutes do you think we can attack facially?
I think that 1610-20 should be attacked facially.
Okay.
Haley makes that hard, but I think that it should be attacked facially. That probably is, the rest of them would be as applied. And then the next thing, Your Honor, again, kind of going, I'm sorry.
No, go ahead.
Oh. And once we decide that this is, I'm sorry. Once we decide that it is political speech, both the state and the legislature have a duty to do two things. They have to show that there is a compelling state interest with regard to what they are doing. And they also have to show that the restrictions on the speech are as narrowly tailored as possible.
So that's what I'm getting held up on again,
Yes.
because that whole line of analysis, the legislature has nothing to do with this, right? Because the statute is what it is.
Right.
So in terms of whether it's been narrowly tailored or whatnot, if it's as applied, that's not really coming in, right?
No, you're right with regard to the attack on the statute, but what I'm getting at is the prosecution here, and the point being with regard to all the statutes that are at issue and everything that they're prosecuting is that as applied, none of them can stand because, and I'm about to get to this, because there is counter speech available. And the counter speech that's available, and that's discussed a lot in Arneson, what the courts say is, listen, if you have debate and you have false speech, the Supreme Court has said, listen, the remedy for speech that is false is speech that is true. This is the ordinary course in a free society, and the response to the unreasoned is the rational, the uninformed, the enlightened, the straight-out lie, the simple truth. And what happened in Arneson is that the court said, listen, if you say something false with regard to this ballot referendum, somebody else is going to pick up the ball and say something true. And you're going to have an invigorated debate about those issues, and that'll wash out in the election. What do we know about this case? Every single thing, every act, every count that's talked about in this case was published in real time. Every single thing was very, very hotly contested. There was more than enough, a ton of counter speech. And what happened? What happened is the court challenges were resolved. Joe Biden was put into presidency in January of 2021. And we were done.
But I don't know if that legally makes a distinction, because if, as the state's theory as alleged had succeeded, you wouldn't then say here, I would have presumed that a prosecution is now greenlit under these same principles.
Under these same, I'm sorry.
If it's violating free speech regardless,
right.
It doesn't matter whether it was successful or not.
No, it doesn't matter whether it's successful. No, that's exactly right. All I'm saying is that part of the American experience is saying, listen, we're going to allow, it doesn't matter whether it's successful or not, absolutely right. But what I'm saying is that the counter speech here that was available led to a result that apparently the state wants. And the counter speech led to robust debate, court cases, and you got a result. And that is what the framers were trying to protect. That's what Arneson was trying to protect. That's what the United States Supreme Court is trying to protect in virtually every single case that they talk about. And I've noted here that when you look at the various cases, and I've cited a ton, these are a hand, I mean, you can cite Supreme Court cases and First Amendment cases all day long. But in all of these cases that the Supreme Court raises when it relates to political speech, it is almost invariably going to fall out on the side of let the speech occur. Even if it's false, even if it's fraudulent, when it's in the course of an election, and especially a presidential election, and especially when you're going to have people on the other side going at it hammer and tong to figure out what is the truth.
When you say even as with fraudulent, do you mean even if false?
Even if false, yes,
okay.
Excuse me. Even if false. And the Supreme Court has come again and again and again and said that this type of speech, we're going to protect it even though it's false. And the state here in its indictment, the entire premise is, well, what you're saying is false. What you're saying is wrong. As of December the 3rd, when you have a result in the election, you ought to have known that Joe Biden was the winner. And because you said Joe Biden's not the winner, and because you filed a lawsuit and you had electors go and vote, and because you got on TV or did a tweet or came up with a legal theory, we want to put you in jail. That is anathema to our history, and it's anathema to the First Amendment. And I also cite cases here with regard to Georgia that are in accord. And, you know, Your Honor, before I kind of jump ahead, we talked a little bit about whether resolution is ripe. The Georgia Supreme Court, in a series of cases, have said that even if you have an as-applied challenge, you need to decide that case up front when it involves a First Amendment constitutional challenge, maybe not the same with other constitutional challenges. It also says that the court can consider a demur based solely on the state's averments, and that's all we're asking here. We're not asking for anything else other than what's in the four corners of the complaint. And so, taking all that, and I've truncated it quite a bit, but if you look at the cases, if you look at what's in the indictment, this isn't close. The defendant's statements and actions here are challenging the processes of the 2020 presidential election. It is political free speech. Once we know that it's political free speech, subject to strict scrutiny, the state tries to impose a viewpoint restriction on the defendant. You did not accept that Donald Trump won, and the entirety of the indictment is focused upon punishing defendants for that speech. And the state cannot show that the prosecution is narrowly tailored or that any of the statutes in the indictment are narrowly tailored, especially when you have counter speech here that is available. And the First Amendment absolutely precludes any of the state's claims here. And I think one thing that I wanted to, hold on one second. All right, got it. Is we are in the throes of this, right? I mean, it's hot, it's emotional, it is something that is topical. And we think this is the first time America has ever gone through this process. It's not. It just is not. I was down in Florida in 2000 for the recount of the Bush versus Gore election. That resulted in the Secretary of State, remember the criticism she got, the Attorney General of Florida running around, decisions of the Florida Supreme Court, hotly contested. Is this ballot fraudulent? Is that counting fraudulent? It goes up to the United States Supreme Court. It lasts until almost January of 2001, about as long as this challenge lasts. And the Supreme Court, in a decision that a lot of people roundly criticize, say, this is the result, it's over, President Bush did not indict President Gore and his supporters for making those challenges. That was their political speech, and it resolved through the courts and through the political process as it should have. And when I'm thinking about, when else did this happen again? What happened in Georgia? It's kind of a history buff type thing, but we probably have all heard that in 1946 or 47, you had the elected governor of Georgia die before he got into office. It's called the Three Governors Controversy. And at that point in time, the Georgia General Assembly said his son, Herman Talmadge, we're going to make him governor. The duly elected lieutenant governor said, no, I get to be governor since I was duly elected as lieutenant governor. The sitting governor, Ellis Arnold, said, I'm going to hang around and I'm going to be governor. The Georgia Supreme Court weighed in. Allegations of fraud, allegations of false statements, allegations that this just ain't right. And the Supreme Court said, well, it's going to be the lieutenant governor. But the members of the General Assembly that said it was Herman Talmadge, they didn't go to jail. Herman Talmadge didn't go to jail. Ellis Arnold didn't go to jail because they were advocating for a position that got worked out through the political process. In 1876, this is probably one of the craziest ones, Hayes versus Tilden. This led to the enactment of the ECA. Tilden was the popular winner. He was one vote shy in the electoral count, and Congress disallowed that one electoral vote from Oregon. They then didn't know who it was. At least according to the research I've done, this almost led to a second civil war. You have Congress put together a 15-member panel to figure out who's going to be the president, and it ultimately gets decided in a hotel room. Nobody went to jail. Very recently in Georgia history, the Kemp versus Abrams governor's election. Stacey Abrams said Brian Kemp didn't win. He illegitimately won. The election was based upon voter suppression. Numerous lawsuits won. She lost every one of those lawsuits. Stacey Abrams wasn't prosecuted, nor should she have been. Al Gore, Abrams, Kennedy, Tilden, Talmadge, members of the General Assembly, they are not prosecuted because what they were doing, even though they were pointing fingers back and forth saying, you're committing false statements, I'm the governor, you're the governor, I'm the president, no, you're the those came out in public, and they were hotly contested, and the First Amendment protected all of that speech. But once we start punishing people for taking the positions and challenging the elections, I've challenged lots of elections in 25 years of practice. I've been involved in tilting at a lot of windmills. Once we start saying that you are going to go to jail for doing that, those types of challenges are going to dry up. And that is precisely why the First Amendment and the Supreme Court have said you can't do it. And to get to a question that Your Honor asked earlier, when has this ever happened in our history? Didn't happen with Tilden and Hayes. Didn't happen with Jefferson and Adams. Didn't happen with Bush versus Gore. Didn't happen with Kemp versus Abrams. This is it. This is the first time that a prosecution of this type has been brought in this country, as far as I am aware. And I heard my friends on the other side said they're not aware of one either. And the reason that these lawsuits, and that's a due process problem, but the reason these lawsuits haven't been brought is because the First Amendment says you can't bring them. We're going to allow the discourse. We're going to allow the statements, even if they're false, because somebody's false statement is another person's truth. And we might be able to prove something down the road, We might have this argument, but once we start letting the winners put people in jail, we're done. We are done. And that, our framers said, we're not going to allow. That is what the Supreme Court said during the civil rights movement when people were making, you're violating the peace. You're saying something that we disagree with. You are making statements about these types of civil rights issues. You got to go to jail because you're standing on a public piece of property and you can't be there. The Supreme Court repeatedly says no. Whether it's your action, your petition to government, your speech, we're not going to allow the state to come in and say, you go to jail because we disagree. It is about as strong a presumption. It is about as strong a piece of law that we have in this country. And again, the reason we've never seen it before is because this is unprecedented. We can have all kind of disagreements about candidates, all kind of disagreements about policy, whether or not we think that what they did was morally right, good, bad, or indifferent. But we don't jail people over this in this country. Your Honor, and then the very last thing I'll say is I think we especially don't jail people when they go and they give their statements to their elected officials and say, hey, I see a problem. Will you guys look into this problem? I see a concern. Will you look into the concern? That's the people you're supposed to go to. Go to jail, says the state. No, I say, and no, says the First Amendment. Thank you, Your Honor.
Thank you, Mr. Nolowitz.
Your Honor, may I address one specific point that I raised in the motion? Good afternoon. I do not intend to reiterate anything that's already been said by co-defendants counsel. He did a phenomenal job. I just want to make certain that the record reflects that that is President Trump, is suggesting to the court that your persuasive authority in the order that you entered in the matters of Chesbrough and Powell, specifically finding that the First Amendment as applied could not be done pre-trial, that Georgia precedent barred such a challenge, that you reconsider that as the authority. Instead, take a look at the case that I have cited as well as has been cited by co-defendants counsel. That's the Hall case.
So in the Hall case, I think it was maybe only 3 or 4 sentences, but there was an aspect of that where the state was willing to say these are the facts. And that gave the Supreme Court something to play with.
True.
And so Mr. Nolowitz here says, we want you to apply it just based on the indictment. Where do you fall there?
I believe that if the state wanted to stipulate the facts that are clear, we would be willing to do that. They've not indicated any desire to stipulate anything. I believe you can do it simply on the indictment and the accusationary facts, those that are alleged. I think that's what the quote that I used from Hall indicates. You take the facts as alleged in the indictment throughout the RICO count. And when you do that as applied constitutionally with the First Amendment, you find that it violates free speech, freedom of petitioning, all the expressions that the First Amendment is designed to protect, and therefore the indictment needs to be dismissed. I'm saying you can do that pre-trial. If the state wants to stipulate to certain facts so that we actually can have this issue drawn in a clearer fashion for the court, we're more than willing to do that, but they don't need to. The accusation, the indictment alone is sufficient, and I think that's what Hall indicates. And I'd ask you to reconsider that particular part of the order. Thank you.
All right, thank you, Mr. Sadow. Why don't we go ahead and begin with the state's argument, and we'll see where we land. I know we had some other counsels stepping in at 1:30 around there, but maybe Mr. Wooten, if you're taking this argument, we can pick it up right there with the Hall case, which was not one any party raised at the outset, but it certainly seems on point on this issue.
Judge, I just would request to be able to screen share. think I've got the.
Yeah. All right, so we need Mr. Wooten added as an admin.
Thank you, Judge. And I will just jump right into Hall, Judge. As you pointed out, state's position is that Hall does not apply here. It was an as-applied challenge. It was taken up prior to trial, but as the court pointed out, there was at least some set of facts that was not in dispute. So not only, and as the court indicated, the state indicated what it believed the facts would be, and that was part one, but also the defendant did not contest those facts. And as the court pointed out in its order on the prior hearing on this issue, all of these facts are very, very, very contested. You can look
But I think what I heard was Mr. Sadow and the defendants here saying that just for the purposes of an as-applied challenge, they would be conceding the facts as laid out in the indictment. Perhaps not the part where it says everything's unlawful, but the facts as alleged. And then I know this was a 4-3 decision, I know, and so there was a vigorous dissent, but there's the statement in here where Justice Sears appears to say that as-applied challenges should be allowed pre-indictment. What do you make of that?
Well, Judge, I think you hit on something important, which is that if they're not willing to stipulate to all of the allegations, the intent requirement, the unlawfulness, all of it, you can't stipulate to some of the facts that don't establish the offense and say, let's make a decision. I think that's not congruent with Hall. I think in Hall there were facts that were stipulated to that, but for the constitutional challenge, established the essential elements of the offense. And then the examination was able to be made on that limited set of facts. And so here, I mean, as an example, let's take a false statement. I think that they would have to stipulate, and not, again, our position is that they can't stipulate just for the purpose of this argument. If the fact is stipulated to, it's stipulated to in the entire matter, is our position. They'd have to stipulate that for a false statement, that the statement was false, that it was within the jurisdiction of a department or agency of state government. They knew it was false, going beyond just the allegations in the indictment, going to, things that they've indicated in their pleadings are required to for a conviction. They'd have to agree that they knew that those statements would come to the attention of a department or agency, et cetera. So I don't know that they're willing. To me, that sounds like a guilty plea.
Well, let's pause there for the purposes of an as-applied First Amendment challenge. Mr. Nolowitz, any thoughts on what facts? If we're just looking at the four corners plural of this indictment,
right.
What facts are to be stipulated to or agreed to?
Well, I mean, I think he's right. I'm not going to stipulate the veracity of the facts for all purposes going forward. I think
That's just for the purposes of an as-applied First Amendment challenge.
Purposes of the as-applied First Amendment challenge.
That everything in here is alleged.
Everything in here, I mean, again, we're not stipulating to it for trial or for evidence therefore, but if you were to look at everything in that indictment, it's saying, just like on a civil motion to dismiss, we're going to take as true everything in there. It doesn't stand under a First Amendment.
Which you just your general demur framework, right? Mr. Sadow, is there anything you wanted to add there?
I would echo that position and have done so in my motion itself, indicating that for purposes of the First Amendment as applied challenge, it's undisputed as to the allegations and vermin in the indictment.
Okay, Mr. Wooten, back to you.
Judge, Hall does not say that the defendant in that case stipulated for the purpose of an as-applied challenge. It says that they did not contest the facts, period. So our position is that you don't get to, stipulate to the facts here, but then contest them here. We do not, I heard from the other side, you do in a demur, but this is not a demur. This is essentially a plea and bar based on a constitutional challenge. It's not the same thing. And to be clear, in a demur, the other side's not stipulating that the facts are true. The court is taking them as true in making its determination as to whether or not the indictment is sufficiently pled. So our position is that there's no such thing as stipulate for the purpose of just this. That doesn't do it. That they would have to stipulate, again, not just to what's alleged in the indictment, but the proof that would be shown at trial, because an as-applied challenge looks at more than just the indictment. It looks, that's what Your Honor exactly pointed out in your initial order on this, is that you can't go just by the indictment. And in Hall, they don't go just by the indictment. There are some additional facts that are stipulated to. And so I don't think that works. The state's position is that approach does not work, that the court still is not able to make a determination, even if they stipulate for the purposes of that motion that these things are true. We don't think I don't think that's the thing you can do. I don't think you can say, we're going to halfway stipulate. Either you do or you don't. Either the fact is stipulated, it is a fact established in the record as true by stipulation, or it's not. It's not a thought exercise. And in Hall, they agree that the facts are true, unequivocally. That's it. And so the state's position is Hall does not apply here because that is not what's happened here. I'm going to move to the other case cited by Mr. Sadow. That's State v. Davis. He cites that as precedent. That's a facial attack. And as the court well knows, a facial attack is presumptively ripe. The argument in a facial attack is that it could never be applied constitutionally, so there's no need for a development of a factual record. So we agree with the court in its first order on this issue that these issues are just not right. There's no facts in the record as it relates to, there's some facts as it relates to some collateral issues, bond revocation, et cetera, but there is in no testimony under oath, no evidence, no exhibits admitted. There's no facts in the record. And so the court cannot make the determination at this point. I do want to hit on a few things, just bigger picture. We heard from the other side these grand statements about this is a prosecution of political speech. This is a prosecution of expression. This is a prosecution of association, petition, et cetera. That is not true. And the indictment tells you so. This is a prosecution for violating the Georgia RICO Act, individuals conspiring to participate in a pattern of racketeering activity while associated with a criminal enterprise. It's a prosecution for solicitation and violation of oath of office, false statements and writings, impersonating public officers, and the list goes on and on. Some of these are crimes involving expression. Some of them are not. Conspiracy is not a crime involving expression. It's a crime involving a corrupt agreement. And the crimes that do involve expression are specifically, we have specific authorization from the Georgia Supreme Court and the United States Supreme Court to prosecute that type of speech. And again, looking at Alvarez, the First Amendment does not protect a few historic categories of speech, including speech integral to criminal conduct, fraud, speech presenting some grave and imminent threat the government has the power to protect or to prevent. And Haley, as the other side pointed out, again, holding that 161020 is constitutional on its face. And so I bring this up to say that, I'm going to go back 2 slides, even if any of these issues are right, as a general matter, the defendants aren't telling the court what they want it to do, because you don't get to come in and just say the prosecution is unconstitutional. That's not how a constitutional challenge works. What statutes are unconstitutional?
It's how an as-applied challenge works, though.
Well, they're not saying, Judge, which statutes are being applied in an unconstitutional way. I guess we've heard all of them, but we haven't seen any analysis in the briefing or in the argument of how each specific count is applied unconstitutionally, has that criminal statute applied to it unconstitutionally. And so the state's position is that if the court's willing to entertain that argument, we'd ask that you make the other side reduce those arguments to writing, give us the opportunity to respond. They weren't in the briefs. And so I don't really know how we can respond to a blanket constitutional challenge that doesn't have any specifics, doesn't talk about statutes, doesn't analyze specific facts. There are no facts in the record, of course. But we don't get that analysis of exactly how each of these counts are being prosecuted in an unconstitutional as applied way. It's just not there. We heard from the other side that this is the first time a prosecution of this type has been brought, that it's unprecedented, and that may be true, but this is the first time a criminal enterprise has gotten together and tried to overturn the results of an election. So I don't think that's a particularly persuasive argument, that this is the first time a case like this has been brought. There's going to be a first time a case under any statute or any situation is going to be brought, and that doesn't make it unconstitutional. And again, Judge, I promise I keep it brief. Our position is that these issues aren't ripe, that the speech or the other expressive conduct that forms the basis for the charge is not protected by the First Amendment. The U.S. Supreme Court has told us that over and over again. The Georgia Supreme Court told us that specifically as it relates to 1610-20. And they're just not sufficiently particularized. As the court pointed out, it's like, is this a facial attack? Is this an as-applied attack? We bounce back and forth, and the state just can't meaningfully respond until they've identified specifically what is being attacked. I'll take any questions. Other than that, nothing further.
Thank you, Mr. Wooten.
Thanks.
Very briefly, Your Honor, again, with reference to the Alvarez case, the Arneson case talks about it and says that, yeah, these certain types of false speech we're not going to give protection to under an intermediate level of scrutiny, but once it gets involved in political speech, yes, we do. The First Amendment covers them. Other thing, just two quotes. A prosecution motivated by a desire to discourage expression, protected by the First Amendment, is barred by the U.S. Constitution, and it must be enjoined or dismissed, irrespective of whether the challenged action could possibly be found to be unlawful. That's in our brief. U.S. versus PHE 965, Fed 2nd, 848. Freedom of speech is protected not only against heavy-handed frontal attack, but also from being stifled by more subtle government interference, such as via post hoc prosecutions for political expression and activities under the guise of enforcing general criminal prosecutions. That's in our brief, and they have not been addressed here. It is staggering to me, that the state would stand up and say, we accept every allegation for the purposes of this indictment. We'll accept them all as true. And they can't defend it under the First Amendment. But where in there is there non-political speech? How are you defending this? If everything you say is true, it's ripe for decision. That's what Hall says, and they're not defending it. One thing I wanted to point out, and I should have pointed out in my original argument, and it's in our brief as well. All this is in our brief. They decided not to respond to it. It's in our reply brief too. Is the state has looked at, and this goes to the unprecedented nature of this, the state is saying, listen, you have violated the election laws of the state. You are interfering with the way in which presidential electors are chosen. Voter challenges are made. There's a place, it's called Title 21 of the Georgia Code, 600 annotated pages. I looked at it. I've read it. I know it. 90 sections talking about prosecutions, felonies, misdemeanors. That code, those actions that the General Assembly put together to ensure that we have free and fair elections in this state, doesn't make its way into the indictment. Not one place. Rather than looking at the state election code They turn to Title 16, RICO, lying to officers. And they sit there and they try to mold these other statutes into a crime related to the elections of this state. And it's a bad fit. And it's a bad fit for all the reasons that we have said. And had the General Assembly wanted to prosecute the types of things that the DA is saying, it probably would have done so. It would have done so in the election code. And had it done so, I'd be sitting there saying, that's unconstitutional. Thank you, Your Honor.
May I address? Again, I will be specific. I've taken another look at Hall, and I searched for the word stipulate. It doesn't exist. Hall had nothing to do with stipulations. It had to do with a determination to be made on the record that was presented to the trial court. In fact, the opinion points out, because this matter is being reviewed following the trial court's denial of Appellant Hall's motion to quash the accusations against her, the underlying facts have not been fully developed. The state represents to the court, and then it talks about what the state's representations are. It does not speak in terms of what the defendant, Hall, stipulated to. As I said, it's not even in there. But I think the footnote itself, which I mentioned in my motion, and you go to footnote number 2, is most telling. It indicates the dissent urges that in considering Hall's vagueness challenge, which we understand to be the First Amendment challenge there, which would echo or mirror our First Amendment challenge here on freedom of speech, we are limited to the allegations of fact appearing in the indictment. What this means to me, and I'm suggesting to the court, is that all 7 justices were in agreement that you can take the allegations of fact in the indictment and make a determination of an as-applied constitutional challenge. The dissent's only issue was other facts were being considered. We don't want other facts being considered. We are more than willing and have indicated on the record that we will agree for purposes of a First Amendment challenge that the allegations, averments, facts in the indictment are to be taken as true for purposes of that challenge and that challenge alone. It's exactly what Hall suggests. It's exactly what 7 justices would have agreed on based on the footnote number 2. And therefore, we ask the court to find it right to be considered. If additional briefing then becomes necessary, once the court deems it appropriate to consider it as applied, both sides can present our position to the court, much of which has already been done so by co-defendants counsel, but then we can issue briefs and the court can determine law based on the allegations in the indictment as applied. Thank you.
And so, Mr. Sato, on that point, I would say that one of the goals or purposes today is to complete our record on these issues. So I think that if your or any other co-defendant's intention is to make a as-applied challenge firmly under the facts as averred in the indictment, this would be the time to do it. So, not right now, but through briefing.
I was going to say, that might open up a little longer.
In the pretrial stage, yes. All right.
How much time would you give us to do that, sir?
I wonder if we could stay on the same briefing timeline as we had with Mr. Schaefer's counsel.
I believe that was 10 days?
No, I think it was a little bit longer than that. We had the state replying in that instance.
We go to the 15th.
On the 15th. And then any rebuttal or sur-rebuttal, whatever we want to call it, by the 2nd.
It seems appropriate. Everyone agree?
All right.
We're up.
Just to be clear, is that?
I think I think they would be going first, since he's saying that they're doing a more specific as-applied challenge based on the facts of this indictment, and then the state would have the ability by the 2nd to respond. I recognize that that is a time when most folks are off, so if the state needs more time and wants to ask for it, we can take it up then.
Okay, and Judge, just to be clear, would those supplemental briefs also include the issue of rightness? Any additional argument on the issue of rightness?
It can include whatever you want it to.
Okay, thank you.
Sure.
And if the court will permit, we'll try to do one consolidated brief, if that's agreeable to all counsel.
Sounds good.
Thank you.
All right, let's transition over. I believe we should have, we had noticed for counsel for Mr. Meadows and Mr. Clark. I don't know if they were appearing in, they both in person? All right. Is there any way we could make some room at council? I know we're a bit tight here, but. Okay, well then there you have it. We're going to start with Mr. Meadows? All right, sir, if you could introduce yourself for the record.
Yes, Jim Durham for Mr. Meadows. And Judge, for the record, I think I need 90 seconds.
Okay, and your client has waived his presence here today?
Yes, sir.
All right.
Simply, Your Honor, we're just asking for an extension of our deadlines. The 11th Circuit has taken, Mr. Meadows believes this case, as it relates to him, should be in federal court. I know we have deadlines of December the 4th as it relates to discovery. We have deadlines as it relates to pretrial motions on January the 8th, and we've asked simply for an extension as it relates to discovery February 1st.
Our original filing, I thought you were referencing your March date.
No,
You're
sir.
saying the August date.
The August date.
Okay, so back to square one. If the state's now saying August is the earliest we can try this case, counsel are asking to extend a motions deadline until, at least Mr. Clark is until February. I think Mr. Meadows is until April. March 1st, excuse me.
We'll make March 1st.
Does that impact the analysis on your end?
Somewhat, only because of the potential volume of what might be turned over to us.
What, volume of discovery, volume of motions? I don't think they're asking to reset the volume of the discovery. Well, I know they are, but one of them's asking for 1 week on discovery. It's more just when are these motions going to come in? So maybe that's something. If we need to take a minute to discuss, we can. But at the outset, as I noted, and I think Mr. McDougall recognized, I saw kind of a distinction between turning over the initial batch of reciprocal discovery. I didn't see that as, first of all, that's less of a hard cutoff date as our motions generally. You know, reciprocal discovery can be something that's a recurring and rolling basis as soon as something becomes relevant and recognized in that way. But as I mentioned before, and I think this would still apply with equal force here, that we can keep that on this side of the new year. It's more the motion state, I think, that they're asking for more time on. I think Mr. Clark's case has given us more substantive issues. Mr. Meadows, as argued by Mr. Durham, seems more just personal preference. So I'm not as wild about that ask, but I'm wondering if it's even worth having this discussion if we're not even going to be getting into a certified ready posture until the summer.
I understand.
So if you want to confer, feel free, but we'll just hold in place for a minute. Well, Mr. Wade, before you step out, let me say one more thing. I'm also going to be mindful that this doesn't open the floodgates to every other co-defendant. I think if anyone's going to ask for a motions extension, it's going to have to be particular. It's going to have to be particularized and not just, well, you gave one to the other folks, because we're going to have a lot of motions to get through, and I would plan to be using the time come January to start wading into those just like we're doing today. All right. I think we're off the record for now, but if any other defense counsel need to step out, I don't know when the state will be back. All right, let's go back on the record then if we have everybody. Mr. Wade?
So Judge, our obvious goal is and has been to stick to our August trial date. And in efforts to stick to that August trial date, Judge, we don't see an avenue where the court could push past maybe a February 1st motions deadline. If that happens, then depending upon how the court rules, then I think we're still safe. But also the issue of Mr. Meadows and Mr. Clark's actions that are pending in 11th Circuit will start to develop a pattern depending upon what happens in those cases as well. And we just want to be able to move our business here.
All right. And on, I think it's worth taking up since it plays into this as well, the state's motion for the specially set. Just at the outset, I'll say I'm not planning on making any final decisions on that today because I think all parties should have the right to weigh in and be heard on it. I think, correct me if there aren't any more recent filings, but the state filed a motion. We have a response in opposition from Mr. Sadow, and then just another response from counsel for Mr. Eastman. I'm not aware of any other filed responses yet. I'll say, just again, touching on it, just since we're all here together, Mr. Wade, one aspect of that was talking about a final plea date. I don't know if we necessarily need that in a case like this. The state's more than welcome, and it has its own prerogative to set its own deadline for negotiated pleas, but making everyone come in just to announce ready, I don't know if I see the utility in that. But when it comes to the August trial date, I don't know if that wouldn't be unrealistic in a normal multi-defendant case, even with a lot of pretrial litigation. That wouldn't be unrealistic. But obviously there are a lot of unique variables at play here, and so I don't know if that's going to be something that we can determine 6 months in advance. But I guess my question for you on that subject would be, how long does it take, would your estimate be for the state to ramp up, to have its subpoenas out? How much of a runway would you need? And this, I'm not holding you to it. This is more of a ballpark figure. I know you kind of got a trial run in October, but maybe that wasn't the ideal race for you.
Yeah, yes, sir. I would say a reasonable time frame would be 30 days.
Okay. And again, not holding you to that, but generally speaking, you're saying that if at any point, no earlier than a month in advance, the state would be showing up ready to go for voir dire.
Yes, sir.
Okay. All right. And then just because we're on the subject, but without making any determinations today, and because Mr. Sadow's here, I wonder, Mr. Sadow, would you like to weigh in and talk about some of the thought process behind the opposition?
Well, the opposition at this point is fairly simple. My client has a trial date in D.C. in March. He has a trial date in Florida, Southern District of Florida, in May. The New York case, which kind of was the first one brought, if I remember correctly, is awaiting a new date. But is, I think, going to follow the case in Florida. And depending on the length of cases, I don't see how any way this court could be set for trial in August. And of course, well, the state doesn't give it any consideration whatsoever. It's very possible at that time that my client will be running for election for President of the United States for the Republican Party. And that's somewhat prescient, one might think. And I know that the preference would be that he would not be on trial during the time he was campaigning. I think we'd better leave that to see what happens in the matters that could potentially be considered, Your Honor, that might go up on a certificate of immediate review. Again, the court's discretion, which could postpone things. So,
Right, and obviously recognizing as a caveat that this is assuming the indictment goes forward and based on the arguments of counsel. But I want to make sure I'm quite clear on the position. So the first level would be we don't think a August or later time frame is going to work because just a conflict. There's going to be another trial going on at that same time.
correct.
All right, and as a backup, if your client is the nominee, put the case that if he is not, is that no longer at issue? If he was not on trial and he was not the nominee, would there be any hesitation?
If anything changes, if by some strange occurrence he is not the nominee, although of course everyone recognizes he's far ahead in the polls to be the Republican nominee for president. But assuming, I think that's a very low assumption, that he is not, then I think it changes perspective across the board.
And so your request at this point would be that is something that we should at least defer before wading into for a few months.
I believe that that's an accurate assessment of our position. I would point out, I realize the state believes it has an interest here, and obviously we believe that First Amendment rights and other rights. We haven't even brought the presidential immunity motion, which is going to be brought before January the 8th, which I'm suggesting, at the very least, depending on the court's ruling, would go up from one side or the other. Should the review be issued by Your Honor and the Court of Appeals of the Supreme Court of Georgia take it up. But can you imagine the notion of the Republican nominee for president not being able to campaign for the presidency because he is in some form or fashion in a courtroom defending himself? I mean, with all due respect to everybody, and I know what the court is attempting to do is to give justice and due process, and I've said that, and I'll continue to say that. That would be the most effective election interference for the history of the United States. And I don't think anybody wants to be in that position. I would hope the state would understand that if the Republicans believe he should be the nominee, that he should be given the same fair chance to campaign in national politics as the Democratic nominee, which at this point appears to be President Biden. So I hear what the court is saying. So the bottom line right now is I don't think we should set a trial date and see how things materialize and kind of take it step by step.
And to further clarify, would it also be your client's position that he would like to be present for every day of a trial that occurs?
That would be presumptive, I think, on my point to say. There are certainly, we would want to be present for matters involving jury selection and then into the trial itself, because we talk here about jury selection potentially taking a number of weeks or potential months. But I can't speak for President Trump on that at this moment. I need to have more interaction with him and his campaign team and a lot of other people that come into play in making such a decision.
Okay. Mr. Wade, anything you want to weigh in on in reaction? And also, I don't want to leave other co-counsel out of this if they have something they want to add.
Yes, sir. Just respectfully.
Actually, let me do that first. So you get to respond to everything in bulk. Was there anything else that co-counsel wanted to add in on this to the ones that are here today?
The only thing I wonder is if at some point you're going to talk about severance, and that could change the dynamic as well. Regardless of the state saying they don't want anybody severed, you indicated in the past that you thought it would be a severance, and that could affect who goes to trial when.
Yeah. No, there are a lot of moving parts, and I don't mind kind of saying where I am initially and soliciting input. But I'd cut Mr. Wade off. So, Mr. Wade, anything in reaction that you wanted to add?
Yes, sir. Just respectfully, the district attorney has made it clear that she has no interest in interfering or getting involved with this presidential election. Her sole focus is to move this case forward and not with respect to anything that's going on outside of Fulton County, Georgia. Now, having said that, let me say this. Has the court closed the door on possibly entertaining an order that would contemplate both circumstances. In case the case does not move, the other case that the court is believing is going to go forward that would impede our ability to move forward with an August trial date. What if that doesn't happen? So could the court fashion an order saying that if it doesn't happen, then August it is?
Well, I'm wondering how we can square that. So you're saying that the state's position is that this case should not be interfering with an election. Mr. Sadow's position is that by going forward, starting in August, it would last, an estimate initially was 5 months. That was just with 2 co-defendants. That takes you through 2025.
I think it was
right?
4 months.
Right. Well, I'm adding in our buffer and the defense case. I would presume they might want to present some evidence, right? What would be the state's response that having this trial on election day is election interference?
This trial does not constitute election interference. Let's be clear. This is not election interference. This is moving forward with the business of Fulton County. I don't think that it in any way impedes Defendant Trump's ability to campaign or do whatever he needs to do in order to seek office.
Okay, so
Your Honor,
yes, sir.
Buddy Parker on behalf of John Eastman.
Okay, there we go, sir.
This gets back to what Don Samuel's point was. Dr. Eastman does not, if the case were to be continued into 2025 without, that would be an entire year that Dr. Eastman wouldn't have his case addressed. And that was the opposition, that was at the heart of our opposition that we filed to the proposed August trial date. There are a number of defendants, as noted, who were not running for presidency of the United States. So this gets to the issue of severance, and I realize that there are no real right severance motions yet, but that's the point about the opposition to the August trial date, which was apparently triggered by the, we said, arbitrary, capricious, final negotiated plea date.
Well, so as I take it, it wasn't so much your opposition to the date as it's you would be fine with an August date as long as you would be severed.
Yeah, as long as we're knowing we're on trial.
Right.
We would like possibly it being earlier if we could be accommodated, but I realize there are other co-defendants who have other issues that have been raised to the court.
Okay.
It is what it is.
Well, I'll touch on severance here in just a second, but I'll put one more question out to the floor. This isn't one that has to be answered now, but I think it's one that might be worth considering. And so I'd pose the question to Mr. Sadow. If your client does win election in 2024, could he even be tried in 2025?
The answer to that is, I believe that under the supremacy clause and his duties as President of the United States, this trial would not take place at all until after he left his term of office.
Solely as against him.
Solely against him.
All right. And Mr. Wade, again, I'll give you the option to respond if you so desire. All right. I think obviously that's something we're going to be taking up in greater detail in the new year. And when it comes to the issue of severance, without foreclosing any of the substantive arguments for severance that I'm sure will be filed and need to be made and considered, I think, as Mr. Samuel points out, the logistical concerns are still there. Certainly, I think most, at least I know the state, I know in terms of a preference for conserving just court time and judicial resources, the goal would be to try the case once, again, solely from a logistical standpoint. But I think a lot of the arguments and things that I put in that order would still hold true even with 15 defendants. And so, again, just putting out initial reactions is that even if there is a as we get closer to the time of trial, a severance due to logistical issues. It's my understanding under the Joinder statute that the state would have the ability, and it says shall be able to choose the order. And so if we set a limit, that we just feel, court feels 8's the most we can do at once. My initial thought was that there would be, state would be able to choose an A league and a B league. And if cases resolve on the eve of trial, the folks on the B list better be ready to sub in. But that I don't think I can, I'm willing to say definitively that all 15, if that's who are left come the trial date, that no ifs, ands, or buts, they're all joined together. That's where I am now. But like I said, this is more just to solicit input and reactions. So, Mr. Wade?
No, we do know, Judge, by just historically, 12 defendants have been successfully tried. So would the court be inclined to consider it?
I don't want to set a number today. I think, again, we're still a little too far out to do that. But I think we can recognize 12 is not 15, and 12 is very much pushing those boundaries. But as I mentioned, I think the state would have the statutory right to choose who would fill those chairs. And in the interests of efficiency, if one of those chairs is emptied the morning of voir dire, someone else would be filling in.
So 8 is not a hard and fast.
Oh, no, absolutely not. No, not at all. I'm not committing to any number at this point. But that's just how I was, at this point, viewing logistical severance. I don't know, Mr. Samuel, just because you raised the point, was there anything you wanted to add?
Oh, I think the lawyers have all been discussing severance, and I think you described it once as which bucket are we all going to be in, and we've had a lot of conversations about it. I don't think we've formulated a specific response, but if you gave us a deadline to make a proposal, I bet we could meet your deadline.
Sure. All right, thank you all.
Or maybe two different deadlines, one for one bucket and one for the other.
Okay, in the near term, though, we have Mr. Clark and Mr. Meadows who have been waiting here. We've covered a lot of ground since then. I think the state's position was that it was consenting to a February date?
Not past February 1st.
Okay. All right. So if the state's consenting, then again, I was more on the fence with Mr. Meadows, but to that extent, we can say that the motions deadline would extend to February 1st. And we can do that. I think the same with Mr. Clark. Again, we're in another situation where there's a lot going on and a lot changes week by week. So with the state's consent, we'll extend the motions deadline solely for Mr. Clark and Mr. Meadows to February 1st.
Your Honor, on that, assuming that either one of those defendants were to come up with a unique motion which had not been raised by any other defendant, would we at least be in a position to adopt for purposes of the record?
I'll consider a motion requesting to adopt. Let's go that way. I don't think all motions are created equal, and I do want to have that January date be a hard and fast, because so far, I think we've had a lot of hands at the table, and the issues are starting to appear similar in most respects, and I'd like to see what we come up with in January.
I'll
So
take that as a maybe.
we'll go with a maybe. I'll say a maybe, but unlikely. I'll put it that way, Mr. Sadow.
Maybe minus?
It may be minus because with the pretrial litigation that's expected, we have to have a stop date, or at least a start date. Okay, so I think, Mr. McNeil, that handles your business today?
Yes, it does, Your Honor.
All right.
I plan to stick around.
Feel
for
free.
the elevated arguments to come.
Okay, if we're still standing here. All right, anything else then from Mr. Durham? You're also, okay.
Thank you, Your Honor.
All right, so if there's nothing else from the state, then we're moving on. The remaining issues, and that may have taken care of, no, I don't think it did, actually, the housekeeping and discovery issues. But I wonder if we can combine, or if council were planning to combine issues 3 through 7 as articulated by the proposed agenda. No, not so much.
Well, there are a lot of similar issues. I'm doing item number 3, which is the solicitation counts.
Okay, well, let's just start there then. How much time do you need?
At most, I would guess 20 minutes.
All right.
And I do want to
begin, if I can, by making sure the court is aware of how we structure the agenda. It is not defendant by defendant, nor is it even count by count. It's really topic by topic. And there's a lot of adoptions, but it should be clear that, like with regard to Ray Smith's demurs, we demurred to, I don't know how many counts altogether, probably just about everything he was charged with, and he's been charged with the third most counts. But we're not arguing all those today. In fact, Mr. Anulewicz will be arguing the false statement counts to the legislature, even though we're in the exact same counts and even some additional ones. So I'm doing anything that involves the solicitation at the legislature. Mr. Anulewicz is doing anything that involves false statements at the legislature. We are also in a couple counts in different ways dealing with the alternate electors, contingent electors, or the electors. And we adopt, and we'll do it in writing also, all the arguments you heard this morning there. But otherwise, you were going to hear from every one of us on every topic, which we've done everything we could to be more efficient. So the counts, if that's okay with the court. So the counts that I'm going to be focusing on in particular, counts 2, 6, and 23. Those are the three substantive counts alleging solicitation to violate a legislator's, or plural, legislators' oath of office. And they are, in all relevant respects, identical. They differ in dates, and they differ which legislative body Mr. Smith appeared before. And in each of them, there are a number of defendants, and I think we're all adopting each other, but I am handling these three counts, 2, 6, and 23. Count 2 alleges an appearance before the legislature on December 3rd. All these dates are 2020, of course. Count 6 alleges an appearance before the legislature on December 10th. And count 23 involves an appearance before the legislature on December 30th. These are not the fourth time that he appears at the Capitol is with the electors on December 14th. That was argued by Mr. Gilliam, Ms. Pearson, and we adopt their arguments with regard to that, the allegations involving what happened on December 14th and the related time frame. So I'm focusing on the solicitation counts. And the solicitation counts are virtually all identical, again, other than the dates. Let me just summarize really briefly count 2 as an example. And this applies to a large extent on the overt acts in the RICO, but we're not asking you to grant a demur with regard to them because they're not, most of these are not alleged to be crimes at all, even in the as predicate acts. So that's really the substantive counts, 2, 6, and 23. To the extent that any of them are mirrored in a RICO count, actually my partner will be arguing the RICO objection hopefully before nightfall, and she will, the reason we put that at the end, just so you know, is because otherwise she'd be dealing with every single substantive count also. So, so count 2. Count 2 alleges, as I said, that on the December 3rd, 2020, Mr. Smith, along with Mr. Giuliani, Mr. Eastman, Ms. Ellis, appeared before the legislature and unlawfully solicited members of the Senate Judiciary Committee, who were identified, many of whom were identified in the indictment itself, to engage in conduct constituting the felony offense of violating the oath of office. You have a solicitation allegation asking someone to engage in conduct which would amount to a crime, and the crime is violating your oath, the oath you took before you became either a Senate or a member of the House, depending on which count we're looking at, all virtually the same. And then it identifies what you asked the legislators to do, which they claim would violate their oath. All the same, all three counts. They were asked to unlawfully appoint presidential electors from the state of Georgia. Okay? I'm just going to address those allegations because, as I've now said 3 times, they apply to all 3 counts of the indictment. We are challenging these indictments both under under the special demur and a general demur. And I'm, for those of us who spend a lot of time in federal court, and as you did for many years, they are not unlike, in terms of what you're seeking, a bill of particulars, a special demurrage, not unlike a bill of particulars that you would use in federal court. And in old civil practice, before the Civil Practice Act, it's not unlike, a motion for a more definite statement or something else that challenges, I'm talking about special demurrage now. It challenges the amount of information that was given to you in the charging document, whether it even applies in civil cases. And as you know from both parties' submissions, I'm just getting my computer warmed up. You don't need to read a whole lot of case law to understand special demurrage. You really only need to read two cases, and I think they're the cases that the prosecution cites and the defense. And one is the case of State v. Sanders, which the state cites, oddly enough, because it's so favorable to the defense. And the other is the Kimbrough case, which was a fairly remarkable case, finding a special demurrage should have been granted, leading to the dismissal of the indictment. In a RICO case, I don't know who argued that case in the Supreme Court, but whoever did was surely brilliant. Do you happen to know who argued that, Jack? Yeah, okay, yeah, all right. So here's the problem with the indictment, and I, with all due respect to my colleagues, I'm not sure I understand really what their response is, other than we've alleged the three elements of the crime. That's all we have to do. We allege that you solicited. We told you who you solicited and when and what you asked them to do. Period. End of discussion. We don't have to do anything more. And in fact, they didn't do anything more, because at a minimum, what we seek in our special demurrage is, would you mind telling us what oath it is that you claim that we took? What was the oath we took? I've done many oath of office cases. We've represented county commissioners when they do something inappropriate. They engage in some kind of, shenanigans, and they've taken some money they shouldn't take. And you always find out what the oath was that they took. More often, we represent police officers who were alleged to have committed a violation of their oath of office because they did something wrong. Usually, an excessive force case, or maybe some sexual impropriety with an arrestee, or a financial crime. But you're always told what the oath was, because that, in essence, defines what you did that was illegal. You violated the oath, which required that you XYZ. And so we filed a special demurrage in this case to find out what oath it is that you say we took. You think it would be simple. Why don't you just go look it up yourself? Well, the answer is many public officials take different oaths. Policemen, for example, they take an oath under the county, they take an oath by the state. There's 4 or 5 different oaths they have to take. The city, the county, the state, and the oath, the post certification oath. And you're always told what is the oath that you violated. I looked in the code. I started at OCGA 1-1-1 to make sure I didn't miss a certain oath that perhaps a legislator took. This is the first time I've ever had an oath of office case, ever. I've been practicing 40 years, in which the oath wasn't attached to the indictment, or the date that they took it, or at least the content of it is spelled out in the indictment itself. And I found that there was only one oath that legislators take. And if I'm wrong, it shows even more why we're entitled to a special demurrage. I'm assuming that the prosecution doesn't disagree that this is the oath that was taken, but I'm just guessing that this is the oath they're referring to, because I don't know of any other oath they took. We should have been told. But I found an oath in the code at Title 28, never looked at that before, Title 28-1-4. And it says, it begins, in addition to any other oath you took. I have no idea if they took another oath, because they didn't tell us. In addition to any other oath prescribed by law, each senator and representative, before taking the seat to which elected, shall take the following oath. I do solemnly swear or affirm that I will support the Constitution of the state and of the United States. That's it. Then there's a reference to, I'll conduct myself, in accordance with that oath. So I attached, for your benefit, a copy of a decision from a judge down in the Brunswick Judicial Circuit, which was the last oath of office case I took. And there, they alleged you violated your oath. They gave us the oath, in that case at least. And in that case, the oath said, like this, I swear I will defend the Constitution. And the judge said, that's too broad. You haven't given Mr. Samuel, Ms. Clark Palmer was in that case too, you haven't given them enough information. What clause in the Constitution, what part of the oath did you supposedly violate? And I pose the same question here. Assuming this is the only oath, and if it's not, you ought to automatically give a special demur since they didn't even tell us what oath it was. What portion of the United States Constitution or the Georgia Constitution, because that's in the oath also, Georgia and Union Constitution, what clause in the Constitution are you claiming we asked the legislators to violate? Was it the Equal Protection Clause? Because voters in different counties, Fulton County was rife with fraud. Did they get more than one man, one vote, or one person, one vote in Fulton County? Because I've seen election challenges in this election dealing with equal protection. Was it due process? Was it what I learned about this morning, Article 2, Section 1? Is that the violation of the Constitution that was allegedly solicited of the legislators? We have no idea. We don't know what we are going to be defending against. We don't know what it is, what portion of the oath we supposedly violated by asking legislators to, I call them, coronate the electors, which is all they're alleged to have done. Appeared before the legislature and said, please, select these alternate electors. Once we are told what the oath was, which we haven't been, once we are told, assuming it's the Constitution that we were soliciting people to violate, what is it about the Constitution says you can't ask a legislator to appoint an elector? There's nothing in the Constitution that says you can't do that. There's nothing in the Constitution that says a legislator can't do something like that. How does that violate the Constitution? The prosecution's saying it's a crime. We're saying it's constitutionally mandated that we have the right to do that. That's what Ms. Pearson and Mr. Gillen said this morning. But now the state's going to have to say it would violate the Constitution somewhere, somehow. Georgia Constitution, federal Constitution, we have no idea. To even ask the legislature to appoint alternate electors. It's the same in count 2, it's the same in count 6, same in count 23. Exact same conduct each time. The prosecution responds, well, we've set forth the law and the elements of the offense. But that's not what a special demur requires. And again, I'll quote from the Kimbrough decision. The indictment must allege the underlying facts, which kind of gets into the as-applied issues you were dealing with before. But now we're in the context of a demur where Kimbrough said, you must allege the facts which actually constitute the offense so that we are prepared. That's why we've asked, tell us the oath, show us the oath. Put it in the discovery, which would not be a adequate substitute, but they haven't even done that. They say in their response, it's no more necessary for us to tell you how you violated the Constitution than in a murder for hire case to say, whether we want you to use poison, a gun, or a knife. And that's a clever response, but totally inapt. It would be as if, we said, go kill somebody. Would that be enough? A solicitation, go kill somebody somewhere, somehow. That's the amount of information we've gotten in this case as far as the solicitation case goes. This isn't a conspiracy count. These are all, you solicited to these legislators to violate their oath in order to, so that they would violate their oath, apparently their constitutional obligation. They say we can look elsewhere in the indictment, but that's not the answer. A special demur has to be satisfied if the count doesn't allege sufficient facts to allow for the preparation, if the count doesn't allege the sufficient fact, discovery is not a cure. Oral argument here is not a cure. If Mr. Wooten stands up and says, I'll answer all his questions today, that would be a concession that the indictment is not enough. When he responds to this, he should stand up and say, I'm not going to tell you anything more, I don't have to. Because once he starts answering questions and saying, okay, I'll tell you where the oath is, I'll tell you what part of the oath was violated, I'll tell you the constitutional provision that was, you solicited the legislators to violate, he's acknowledging, he's conceding that the indictment was not sufficient, and he had to fill in the gaps by standing in court and telling, is he going to promise, is he going to promise those are going to be the allegations in the indictment?
Well, I know you made this reference earlier. I know the bill of particulars isn't recognized, I think, explicitly in Georgia law.
Right.
But that's essentially what you want.
Well,
You want indictment perfect in form and substance.
that's my next line. Thank you.
There you have it.
You've jumped the gun on that. But the difference between a bill of particulars and a special demur is the relief that has to be granted. Bill of particulars in federal courts are very, can I say, gentlemanly thing to do. And the judge says, just answer his question. You're bound by it.
And you're bound by it.
Yeah. That's not the way it works here. You have to dismiss the count here. It's the only way to resolve a special demur. If you agree that the indictment is defective in terms of not providing sufficient information, you must dismiss that count. That count gets dismissed, and they can re-indict, they can do whatever they want to do. But discovery is not the answer. An informal response in court is not, or even a formal response, even if he takes an oath and tells us what the answer to my questions are. None of that is sufficient. It's a dismissal.
Agreement between the parties, and that's not an answer either.
Well,
Or one that's not at.
We're not going to agree that we don't get a special demur. Special demur says you must have an indictment that is perfect in form and substance. I love Mr. Anulowitz and his colleagues' description of an indictment. According to Kimbrough, according to cases that go back 30 years, they have to get an A. It has to be perfect in form and substance. It can't be an okay or an adequate or even a B+ indictment. It has to be an A. If we were grading on a curve here, this indictment, perhaps, this indictment deserves a B, but only because so much of the remaining parts are so pitiful. So, our special demur is we want to know what was the oath, what part of the Constitution, if the oath is the Constitution, to obey the Constitution, what clause in the Constitution were they solicited to violate? And why would that be a crime? Let me turn to the general demur, which, I have one more example here. This indictment would be as if you were charged with violating your oath of office, or I asked you to violate your oath of office because you came into court, without a robe this morning, or some judge came into court without a robe. Isn't it clearly the law that the judge would be entitled to say, what oath did I ever took that required me to wear an oath? I want to know the oath that you claim I violated. And they're saying we don't even have to tell you that. You'll find out at trial. That's when you're going to find out the oath you violated and the portion of the oath that was violated. Let me turn to the general demur aspects of this claim. Again, the allegation is that Mr. Smith and others, Mr. Giuliani, Mr. Eastman, I guess, and Ms. Ellis, went to the legislature. They're invited to go to the legislature to answer questions of the legislators. And when they go there, they urge the legislators, this is what's in the indictment, this is, forget the facts, outside the four corners. And while there, they make statements that are asking the legislators to appoint a slate of alternate electors. And apparently the allegation is that that violates the Constitution. They're asking the legislators to do something that is unconstitutional, assuming those facts are all true, as a general demurrer must do. That is no different than a lobbyist who goes to the legislature, examples from my brief, and says, you should pass a law that says any book that has the word sex in it should not be allowed in the public library. If someone went to the legislature, a lobbyist went to the legislature and said that, I want you to pass a law that says you can't bring a book that has the word sex in it to a library, clearly a First Amendment violation, right? Nobody would doubt that. But under their theory, you're violating your oath. You're soliciting a violation of the legislator's oath because the lobbyist asked the legislator to do that, to do something that would violate his oath, because he passed a law that violated the Constitution. Think of the pre-Dobbs decision, the abortion cases, where
So this, just to be clear, this line of your argument is premised solely on if the oath that they're referring to is Constitution.
Listen, if I'm wrong about that, I'll sit down. If they stand up and say you found the wrong oath, you just grant the special demurrer and we'll start over again. I mean, really, that's we laugh, but that's the whole point of the special demurrers is make sure I got the right oath, okay? If there's some other oath that the legislators took, I mean, usually they're in writing and they're attached to the indictment. Do they have the written oath, the signed document? The problem with this, from a general demurrer standpoint, is even if they did that, even if I'm right that the oath of office they violated was the oath to obey the Constitution, it's not a crime. We can admit every fact, other than obviously the allegation that it's unlawful. You don't have to ever concede that fact for a general demurrer. And it would violate the First Amendment to say you can't go to the legislature and ask them to pass a law saying all abortions should be illegal, pre-Dobbs. Right? Because that was unconstitutional at the time. Roe v. Wade said that all abortions can't be illegal. You're not allowed to go to the legislature and ask them to do something like that because you're soliciting them to violate their oath, which is to be constitutional. And the solicitation statute, the Davis case that Mr. Sadow raised before, and I think is not Hall, but Davis, the other case, what you're asking the legislators to do, it has to pose a clear and present danger. That's the Davis decision. A clear and present danger that they're going to be committing a crime if they did it, if they followed through on the solicitation. That's Davis, 246 Georgia, 761. Not only is there not a clear and present danger, it's not even a crime. It's not even a crime. It's this compound defense where you're violating the oath of office, which doesn't violate anything. There's nothing in their oath that says they can't pass a law that's unconstitutional. They do it all the time. Don't tell them I said that, but they do it all the time. That's why we have challenges to statutes all the time, challenging the constitutionality of statutes. Your brethren on the bench in this courthouse have found statutes unconstitutional. Did they throw the legislators in jail? Did they say the legislators violated their oath of office when they passed the law? Of course not. Other aspects of the First Amendment that apply to the general demurrer here is the lawyer's duty. We talked about that a little bit in our brief, to advocate on behalf of a client, to urge legislators. This is, I'm trespassing a little bit on Mr. Anulowicz's First Amendment argument. So asking legislators to appoint presidential electors doesn't violate the Constitution. Doesn't violate the legislator's constitution, even if they were to do it. You couldn't put the legislators in jail for doing it, not for violating their oath of office, not for violating the United States Constitution. We'd ask you to start with the special demurrer and then move on to the general demurrer. If their answer is yes, the only violation we're alleging is the violation of the oath to obey the Constitution, and the only violation of the Constitution is exactly what is described in the indictment, requesting that they appoint alternate electors, then we believe we are entitled to a demurrer. The only other thing I'd mention, I mentioned the Sanders case and the Kimbrough case. In Sanders, the allegation in the indictment was you solicited someone to either possess with intent to distribute or to distribute a controlled substance. It's clearly a crime, clearly alleged as a crime under the Georgia Code. And Justice Bethel said, that's not enough. You have to say which drug. Okay? You have to say which drug it was that the defendant was solicited to possess. It's not enough just to set forth the elements of the crime. You have to give them more information. And that's the Sanders case, and it's even in the state's brief. They cite even that portion of the Sanders case, that it's just reciting elements of the offense doesn't put us on sufficient notice of what the crime is.
Thank you, Mr. Samuel.
Thank you.
Following on Mr. Samuel's argument.
1 second, sir. We got to get our court reporter back up.
Following on Mr. Samuel's argument, I want to talk specifically about additional issue that applies specifically to count 23. In that count, they're charged, Mr. Cheeley, Mr. Giuliani, and Mr. Smith are charged with solicitation of the violation of oath on December 30th, in that they allegedly solicited the Georgia State Senators to violate their oath by appointing the alternate slate of electors. Your Honor, this is subject to general demurrer because it's a temporal impossibility. Looking at the indictment, as detailed in Overt Acts 78 through 85, the contingent alternate slate of electors was done, was completed, and the associated paperwork had been transmitted on December 14th, 2020. And incidentally, none of those overt acts involve or name Mr. Cheeley. As the actions have been completed well before December 30th, as is described in the indictment, there is no possibility, even admitting every fact in count 23, that any of those defendants could have solicited them to violate their oath, because what they were supposedly being solicited to do had already been done and had already been complete. Thank you.
Your Honor, I have one point to address. Your Honor, I address the matter that was raised by the state's motion to restrict, which the court has already commented on. I just wanted to point out that in the motion to adopt, the first one that I did, which was filed on September 11th of 2023 as to Mr. Smith, and also I did an amended motion to just be as clear as I could be on October 24th, 2023. I indicated in a footnote on page 1 that Mr. Smith, that is the defendant that Mr. Samuel represents, that his demurrers to count 6 applies to counts 5, 28, and 38, which charge President Trump with the same offense. All 3 of the offenses involve solicitation. The oath issue is the same. The First Amendment issue on Davis is the same. We don't have the legislature issue. So those have already been brought to the court's attention through my adoption motion. It's nothing that was new to the state. It's right there in the footnote on both of the documents that I filed.
Okay, thank you, sir. Mr. Wooten, I presume. All right.
I'm going to go a little bit out of order, starting with the argument related to temporal impossibility. That is a pure speaking demurrer. That's going to facts outside what's alleged in the indictment. It's void. The court should disregard that argument altogether. Moving on to Mr. Samuel's argument. He makes great arguments if his client were charged with violation of oath of office. And his client is not charged with violation of oath of office. He's charged with solicitation of violation of oath of office, which is an entirely different crime with entirely different elements. Our inchoate offenses, solicitation, attempt, conspiracy, do not have the same elements as the target offenses. Any target offense. You can use any other offense as a target offense for one of those inchoates. They don't have the same elements. They have different elements, and so the pleading requirements are different. And each of these counts survives general demurrer. They all allege the essential elements, and they all apprise the defendant of what he or she must be prepared to meet. And they provide enough detail to protect against double jeopardy. Again, Indictment is not required in this case because of solicitation to allege the oath of office or the portion of the oath violated. So let's look at the elements of criminal solicitation. With intent that another person engage in conduct constituting a felony, a person solicits, requests, commands, importunes, or otherwise attempts to cause the other person to engage in such conduct. Those are the elements. That's it.
Sure, but maybe let me try this argument out on maybe a count that is litigated a little bit more frequently. And solicitation, you'd have to, is an umbrella that encompasses some other felony because something has to be solicited. So I'm just thinking off the cuff here, felony murder is an umbrella count that has to have a predicate felony. And when we look at an indictment, usually, like with a felony murder count, it's going to say aggravated assault. And we can go down the indictment and we'll look at the aggravated assault, and then there'll be a little bit more detail about that aggravated assault. But we don't have that in this indictment, do we? Where there's a little more detail about that count.
I disagree there, Judge.
Okay.
I disagree. Let me see if, let me skip ahead to that portion. Well, let me just talk about it. I don't have the case site in front of me. The case law is very clear on this. And the other side, I believe Mr. Nolowitz talked about this in his reply to our response. Cited a case saying that every count has to allege everything.
Well, I'll take your point that you can do the entire indictment, right?
Right.
Okay.
Right.
So we can look at the whole indictment.
Right.
Where else in the indictment do we break down what part of the oath was violated? He needs to know whether it's the Constitution or whether it's, I don't even know what else is in the oath, but
And Judge, that's where
not
we
to be a
disagree.
communist. I think that's usually in there, right?
Right.
But what part of the oath, where else is that in the indictment?
That's where we disagree. That the portion of the oath does not appear in the indictment, but the state's position is that it does not have to appear in the indictment because the portion of the oath is something that has to be pled for a violation of oath of office, not for criminal solicitation. They're completely different pleading requirements. And I give an illustration to that. It wasn't solicitation of murder. Mr. Samuel said we use an argument. It's not murder because there's essentially one way to commit malice murder. I use aggravated assault for a reason because there's at least 4 distinct ways to violate the aggravated assault statute. And does a person who's soliciting someone to commit aggravated assault have to specify?
Do we have a case on that?
We don't. Admittedly, we don't. I think there's one case that deals with a special demur to a criminal solicitation count, and that is Sanders, and it's dealing with the controlled substance issue.
So then the answer to this could be yes.
Our position, and we argue to the court that it's not. And the reason why is because the person who's doing the solicitation in this situation doesn't have to know how the person that they're soliciting is going to commit the crime. And so if they don't have to know how the person is going to commit the crime, then how could the state ever allege how they solicited someone, like what specific provision of the aggravated assault statute they solicited someone to commit if they're not required to do that in the first place? And so the example that we use is that, if person A goes to person B, says, here's $10,000. I want you to take care of person C, rough them up real good, make sure they're never a problem for me again. That's enough. It doesn't matter if, a person B shoots person C, commits a drive-by shooting against person C, strangles person C, clubs person C, maces them. None of that matters. Those are all separate and distinct ways of violating the aggravated assault statute. But if person A is not even required to know how the statute would be violated, then how would the state be required to allege the manner in which A solicited B to violate the statute? It's impossible. So it can't be a requirement that in criminal solicitation you have to allege that a solicitation was done in a particular way because the solicitation itself doesn't have to be done in a particular way. And again, the state can't allege what specific provision person A solicited B to violate because person A never specified one. And that's the same way here. None of these defendants said, I want you to violate this portion of your oath. They're not even, I don't know that they're required to even know that the legislators have taken an oath. That's not raised, and that's an issue for another day. But none of them say, I want you to do it in this way, or I want you to do it in that way, or I want you to violate the Georgia Constitution, or I want you to violate the United States Constitution, or I want you to violate this provision. They're not required to solicit in that way. And so the state cannot be required, in order to be guilty of the crime, so the state can't be required to plead something that doesn't have to be proven. And again, the cases that are relied on by the defendants are inapplicable.
Is there a distinction there, though, between what the state has to prove in terms of knowledge and what the state has to prove as of the effect of their actions? If that makes sense. So, yes, the state doesn't have to prove what aspect of the oath that they were soliciting the violation of. But if the state does have to show the ultimate effect of it, or that's.
And Judge, I think to answer your question, the state may have to prove knowledge. I don't know, but we're not talking about proof because these are motions to dismiss an indictment. We're talking about allegations. And so we point that out in some later arguments, and we point that out in our briefs, that often in these arguments we see the defendants conflating, sufficiency of the evidence with a pleading requirement, and they are not the same thing at all. And so, while we may have to prove at trial X, Y, or Z, we don't have to allege all of those things. And so there's no grounds upon which, in our opinion, and again, it's to my point, cases concerning sufficiency of the evidence, they're irrelevant to a demurrer because that's not dealing with what has to be pled in an indictment. That's dealing with what has to be proven at trial. And they're very, very different things. Also, it's irrelevant that it's not a violation of oath of office to enact unconstitutional legislation. The indictment doesn't allege that they asked legislators to enact unconstitutional legislation. It doesn't specify exactly, how they were to unlawfully appoint presidential electors, but that includes getting rid of the actual will of the voters in this state, throwing those out, and figuring out some way to say, nope, these are the electors. The defendants themselves weren't quite sure how they were going to do that, so there wasn't a fully developed plan. And I hesitate to speak to facts outside of the indictment, but I don't find this to be a compelling argument. Again, because it alleges criminal solicitation, and it's for the jury to determine whether or not the proof rises to the level of proof beyond a reasonable doubt of criminal solicitation. Again, I don't know that this argument was raised in the oral arguments, but in the briefs there was an argument that it's not a violation of oath of office to do X, Y, Z, or maybe they're immune because of legislative immunity. None of that matters because the solicitation statute itself says it's not a defense to prosecution for criminal solicitation. The person solicited could not be guilty of the crime solicited. Again, there was raised in the pleadings that we haven't alleged a nexus between appointing presidential electors and official duties. Well, that nexus appears in the Constitution, but once again, this is an issue of proof at trial and not a pleading requirement. Again, Judge, these motions should be denied because this is a criminal solicitation charge. The elements of the offense are different than the underlying target crime. We do not have to plead that level of specificity. It's not a defense that the legislators couldn't have been guilty. The remaining issues are for the jury. And I do want to point out, Judge, that as it relates to the special demurrer, what we do allege, and this is contrasting with Sanders because in that case, it is a very, again, like I said, that's the one case on demurrers to solicitation charges. In that case, they didn't really allege anything. In this case, we allege who was solicited, where they were solicited, how they were solicited, what they were solicited to do. There's a laundry list, why they did the solicitation. It's not a mystery of what these defendants had to be prepared to meet at trial. That's the ultimate question. Do they know what we're talking about? Does the indictment tell them what crime we're talking about? And does it protect them against double jeopardy? And when you read it as a whole, it's very clear. It tells these defendants what conduct is being charged. It prevents double jeopardy, and that's sufficient to withstand a special demurrer.
Knowing
in the indictment what the oath was, I don't know how Mr. Wooten can seriously say we know what we asked them to do was a crime. If we don't even know what the oath was, or whether they even took an oath. The problem here is there's a number of ways that I think Mr. Wooten mischaracterizes our motion. If I asked someone to, go cross the street or something, and he would say, well, you asked them to cross the street, and we're claiming that that's a violation of the law. You'd have to say, what law did you violate? What law did you ask him to violate? And define the elements of that crime. They're just saying, they're not even saying that we asked anybody to violate their oath. It doesn't even say that we said, I want you to go out and violate your oath. However you feel like doing it, just go violate your oath, Chris, okay? Just go violate your oath. It's a compound crime that requires that we have knowledge and intent that you will violate the oath. We're soliciting them to do something to violate his oath, and they won't tell us what the oath is. Sanders talks about compound crimes, that you have to allege the elements of the various aspects of a compound crime. It's not just the controlled substance case in Sanders. The prosecution conceded that the felony murder count was also defective, because all it said was you committed felony murder in the course of an armed robbery. You didn't allege the armed robbery sufficiently. And I was worried that the prosecution conceded and that was it. But no, Justice Bethel said, and appropriately so. They were right in conceding, because even that count of the indictment was defective. Both the felony murder for not alleging the compound nature of the crime, you got to prove both of it. And the fact that the oath isn't provided at all. And of course, the other part of Sanders shows the level of detail. And listen, if you want a list of special demurs, I can send you a supplemental list in 5 minutes, because we're dealing with the same issue in the Cop City case. And there's just dozens of cases in the Georgia Court of Appeals which have held that the defendant is entitled to know what you're going to prove at trial. Otherwise, we can't prepare a defense. I still don't know. I know I said that he shouldn't stand up and tell us what the Constitution was. Maybe informally after court today he'll tell me. And at least we'll know then if you don't grant the special demur. But the law requires, respectfully, that you grant a special demur and say what was the oath and why, what clause of the Constitution, assuming it's the Constitution, was your oath, what clause in the Constitution do you claim it violated? Was it Article 2, Section 1 that Mr. Gillen talked about this morning? Was it the Equal Protection Clause, due process, whatever? It's not to violate a Georgia statute, because I can't find that anywhere. So if he was asking the four of them, or however many people in the count of the indictment, asking them to shoot someone, it wouldn't even be a violation of their oath of office, because legislators, apparently, their oath doesn't include don't violate Georgia law, like police officers. We're entitled to a special demur. The special demur be granted. We're entitled to an indictment that is perfect.
All right, thank you, Mr. Samuel. Why don't we take a hard 5 minutes and be back and see how much further ground we can cover. Starting to think we may need to reconvene, and we'll see what we can do then. All right, be back in 5. All right, back on the record. Item 4, false statements and false writings.
Your Honor, I have more PowerPoints. Access. the attacking certain accounts of the complaint because they do not, as Georgia law requires, plead out every element of the Supreme Court is clear that in order to withstand a demur, the state needs to plead every single element of the claim and needs to plead facts sufficient to show that. With regard to 161020 counts, which is counts 4, 3, 4, 13, 19, 25, and 26, the state does not do that. Where we start is a Haley versus State case that I talked about earlier. 161020 makes it a crime to knowingly make a false statement to government within the jurisdiction of the state or local department or agency. What the Haley court found, and Justice Namias wrote, is that if you were to look at that statute and just say that it had those two simple requirements, that it just said that the defendant must knowingly and willfully make a statement, and that the false statement must in fact be within the matter of a jurisdiction of a state, department, or local agency, that would be unconstitutional. It would be unconstitutional because the second element, the false statement must be made in a manner within the jurisdiction, also has to be made knowingly and willfully. And Justice Namias went through great lengths to say that were it otherwise, the statute would be unconstitutional. And the court was very concerned about it, so it narrowly read and I think did a lot to try to help the statute. But they said, if a person making a false statement need have no knowledge of intent of any kind, that his deceptive statement will come to the attention of a government agency within the authority to act upon it, then the basic due process notion of fair notice would be in doubt. And 161020 would criminalize a wide array of statements that would have always been deemed, at least legally, doesn't have to be morally, at least legally innocent, and the statute would be a trap for the unwary. And so in trying to rectify the First Amendment and due process concerns.
So, Mr. Knowles, I do remember the Haley case.
Yes.
and the issues that were raised there. And so jump into the heart of it.
Yep.
If I remember, actually the language in Haley spells out what was charged. And it says that it was sufficient, right? So sure, it read in an interpretative way an extra element, but did it require or create a pleading requirement, and how so?
The answer to that question is yes. It did create a pleading requirement. What Haley was doing, it was a statutory interpretation. They were going at the statute head on and saying, listen, the statute is unconstitutional. Justice Namias was going to read it in a constitutional way, and so he said to avoid the constitutional problems that he was concerned about, and they're long, and then footnote 1, which is in my presentation, but you can also read it, talks about some of the absurdities. He said to avoid these absurd and patently unconstitutional result, the court imposed a mens rea requirement on 161020's jurisdictional. And what he said is we conclude that a false statement, when properly construed to require that the defendant make the false statement with knowledge and intent that it may come within the jurisdiction of a state or local agency is constitutional. And he said, accordingly, we hold that 161020 requires proof that one, defendant knowingly and willfully made a false statement, and two, that he knowingly and willfully did so within the jurisdiction of the state or local department. Those are the two elements of the crime.
So that was a element created through that, or recognized through that opinion. But generally, when we're talking about whether a indictment is pleaded sufficiently, we're talking about the elements imposed by the statute. And so did Haley go so far as to say that there was a statutory element that was created?
I think that what Haley did, and if you read it, in my view, what he did is he said, okay, listen, within the four corners of the statute, I see the word knowingly and willfully in there. And the way that the statute is written, it's kind of unclear whether that is transitive across the words that are there to get to jurisdiction. But I'm going to read it because it's so unclear. I'm going to say, yes, it does apply there. Okay? So Justice Namias said, listen, okay, it says that. It says knowingly and willfully made a statement and knowingly and willfully within the jurisdiction. So both of those are elements. And what we know from the cases that Mr. Samuel said, from Kimbrough, from Jackson, from all these cases is that you have to plead every element of the crime. The court has explicitly told us what those elements are, and they are not in count 26.
And it's split them up, but the language of the statute remained the same.
Right, the language of the statute, but that's like my saying, and I'm probably going to get this wrong, but I have a brown coat and tie. Brown goes to coat and brown goes to tie. The way that Justice Namias read the statute, the Supreme Court, I keep saying, the Supreme Court read the statute.
You have a brown tie and a brown shirt. But is that a pleading requirement? I just don't see Haley getting to that point. It's an interpretive requirement.
Haley doesn't say that that's a pleading requirement. What Haley says is that those are the elements of the crime. And then we see the other case law that says you have to plead every element of the crime. So of course, and how do I know that's right? Because I know that's right because Justice Namias said, if you don't have to knowingly and willfully have the jurisdiction, unconstitutional. So you have to have those two elements. And when we look at the manner in which every single one of these counts is, I have an example of here, which is count 26 with regard to Mr. Cheely, but it's the exact same language in 4-13-1925. They break it up into three things. Number one, it says, this is what it says verbatim, excuse me. And so the first part says, and the grand jury, in the name and behalf of the citizens of Georgia, do accuse Robert Cheely with the offense of false statements in writing for said accused in the county of Fulton in the state of Georgia on or about the 30th day of December 2020, knowingly and willfully and unlawfully made at least one of the following statements and representations to members of the Georgia Senate present at the Senate Judiciary Subcommittee, colon. So what does this say? This says that he made a false statement to the Georgia Senate Subcommittee, okay? Maybe that meets element number one of Haley, knowingly made a false statement. As a little side, we know that the second part, made it to the Georgia Senate Subcommittee, is irrelevant because the Georgia Senate Subcommittee is not an agency or department of the state. The state concedes that in their briefing. So the first part, knowingly and willfully made a false statement. What does the second part of the count say? Well, here it goes on to say, well, this is what they did wrong. These are the false statements, that they saw a water main break, and that they voted ballots over and over again. Again, we pointed out in our brief, Willis has made these same comments, but has not, but decides to prosecute Cheely for them. But in any event, those are the second part of what count 26 says. So then we get into the last part of what count 26 says, and this is the critical part with regard to Haley. It says, said statements being within the jurisdiction and office of the Georgia Secretary of State and the Georgia Bureau of Investigation, departments and agencies of state government, county, and law enforcement agencies. What those are, I do not know, and that would in and of itself require a special demur, but contrary to the laws of said state for the good order of peace. Haley explicitly says two elements. Number one, knowingly made a false statement. Number two, knowingly did so within the jurisdiction. What does this explicitly not say? It doesn't say that they knowingly and willfully did it within the jurisdiction. Now, that in and of itself warrants the dismissal of all of those counts because every element of the claim is not made. Why they did it, they had 2.5 years. They either A, didn't have the belief or the proof for it, which I don't think that they could have possibly had. And so in good faith, they didn't put it in there, but it is not in the indictment. And because it's not in the indictment, those counts fail. It's a mechanical issue and it's an important issue because they are essential elements of the claim to make the claim constitutional. And that's exactly what the Supreme Court has told us. The only place we see knowingly and willfully at all in the statute is with regard to the first portion where it says you knowingly and willfully made it to the General Assembly, but you cannot give a fair reading of count 26 or any of these other counts to say that that phrase somehow carried forward into the rest of the paragraph. And you have a number of breaks. I put some grammar rules here saying that a qualifying phrase should ordinarily be given as modifying only the noun that immediately precedes to it. But what do I know about this? It's an adverb, right? And when I look at the said statements being within the jurisdiction, what verb would that modify? None. So it is not in there, and it's just not there, so the count fails. A couple of other statements about these claims, counts 4, 25, and 26. These are, again, statements made with regard to the Senate subcommittee. These statements are to a General Assembly. They're protected, okay? The General Assembly, and we put this in our brief, has made the conscious decision that they are going to encourage, going back to my First Amendment argument, are going to encourage as much free speech as they possibly can to allow people to come and speak in front of them. They do not have an oath requirement. They do not have subpoena power. The statute that allows, I think it's the Ethics Committee of the House or Senate to go, they'd have to come to this court to get a subpoena, but the House and Senate have no other oath abilities, no other subpoena abilities. As we point out in our brief, in the 2021-2022 session of the General Assembly, they sought to introduce that requirement, saying that every buddy that comes and speaks before any committee could be under oath. They made the conscious decision not to do that, and they do it to encourage people to go testify. I've testified down there. I've seen some nutty stuff said, and I think that they just want people to come and talk. Well, if that's their goal, and that is within the General Assembly, they are encouraging through their committee meetings and asking people to come and speak. When the executives of this state and the DAs of this state are coming in and prosecuting people for going in front of the General Assembly to give them statements that the General Assembly or the subcommittees are asking for, that impedes upon the power of the General Assembly, and it is without the jurisdiction of these various entities that are put in 161020. Moreover, if you look at counts 13 and 19, and this relates to the statements regarding the electors, and Mr. Samuels points this out in one of his briefs, these cases relate to statements regarding the electors. They don't plead mens rea anywhere. When Mr. Samuels made that point, the state in its brief says, aha, we don't say who the statements were made to at all. We don't say who received the document, who relied upon it, and if they don't say that, then for all the reasons we just talked about with regard to the oath, that fails to provide adequate information with regard to the claim. And because they don't say to whom the documents were given, to whom these allegedly false statements in counts 13 and 19, that's subject to a special and general demur. We've talked about it being barred by the Electoral Count Act, barred by First Amendment, and barred because, again, applying the rule of lenity and due process, nobody ever in this state has been prosecuted for going in front of the General Assembly and telling them something in front of a committee or a subcommittee, not ever, not once in this state. And I don't think that the state can show you anything to the contrary. And because of that, I think that we see, and the reason you don't see that, again, the First Amendment, again, because it's within the province of the General Assembly, it simply is inapplicable, and the state's attempt to assert these 161020 claims fails for all these reasons, primarily because they don't plead the knowledge requirement, and then secondly for the other reasons that I've raised. Thank you, Your Honor.
Judge, I'll start with Haley. The indictment is not required to allege that a defendant knew that false statements would come to the attention of a covered entity. That's an evidentiary concern, not a pleading requirement. How do we know that? Because in Haley, I flipped the slide, Haley told us exactly what the indictment in that case alleged. It did not allege that. if the indictment in Haley had to allege that in order to allege a crime, then the court in Haley would have dismissed the case because the indictment itself never alleged a crime in the first place, and a general demur issue can be raised at any time. So it clearly does not impose an additional pleading requirement. You have to separately plead knowing and willful as it relates to knowledge that will come to the attention of someone. That is purely an evidentiary requirement that trial does not impose any additional pleading requirements. It's irrelevant that the legislature is not a department or agency of state government. Haley tells us that as well. Simply, the false statement must concern a matter within the jurisdiction of a municipal, county, or state department or agency. To whom that statement is made is not relevant. In Haley, it wasn't made directly to any person. It was put on YouTube, and it was put out for public consumption. And coincidentally, in this case, the legislative hearings were broadcast on YouTube as well. The contention that the false statements cannot be prosecuted because the same statements were made in immunized legal pleadings, that's unsupported. There's no authority that legal pleadings are immune from prosecution. This was raised in the briefs. To the contrary, there are specific statutes that criminalize false statements in pleadings, and we cited in our brief a couple of instances, such as an attorney being disciplined for making frivolous pleadings and filings. OCGA 51-911 creates a civil cause of action for defamation of title involving false pleadings, and then 1610-20.1 obviously makes it a felony offense to file false documents. So I'm not sure where this idea of immunized legal pleadings comes from, but it's not supported. Legislative privilege does not apply to statements made by third parties to legislators. Defendants, again, provide no authority for that contention. It's raised in the briefs. You look at the Constitution, the constitutional provision, Article 3, Section 4, Paragraph 9, that creates legislative privilege. It's very clear that it applies to members of either house, not to the general public who shows up and serves as a witness. The fact that they're not under oath, again, is not relevant. That would create a different crime. We're talking about false statements, and we've alleged the essential elements of false statements. Again, under the defendant's theory, in Haley, if that defendant had come to the legislature as a witness and said that he was the catch-me killer and killed 16 people, knowing that that was going to be broadcast live to the world, for whatever reason, he would be immune because he said it at the legislature. That doesn't make any sense. There's no requirement that the counts concerning false documents allege that they were used anywhere in particular. That's not an element of the offense. In any case, we've talked about how, for special demur purposes, you can look at other counts of the indictment, and other counts of the indictment allege where those specifically named documents were used, how they were used. And this is the citation I was looking for in the last argument. Although each count of an indictment must be complete within itself, contain every allegation essential to constitute the crime, that applies to the offense, not the form, and the indictment is read as a whole. Special demur, of course, is a challenge to the form of the indictment, so that rule of count having to be complete does not apply in the context of a special demur, only a general demur. We got an argument in the pleadings that the Secretary of State and the GBI don't have jurisdiction over these false statements. That's looking at facts outside the indictment that constitute the speaking demur. There's no requirement, this is raised in the briefs, that the counts alleged defendants knew that their false statements would cause harm, not an element of the offense. No authority that false statements cannot apply to statements made to the federal government, raised in the briefs. Again, the recipient of the false statement is not an element of the offense. So it doesn't matter. As long as we allege that it's in a matter within the jurisdiction of one of these agencies, and then we prove at trial that there was knowledge that it would come to their attention. In any case, the indictment alleges that those false documents were also transmitted to state officials. And again, we got the rule of lenity argument. We saw this come up a lot in the pleadings. I think this is the first time that it's come up.
I think you handled that. I haven't seen it come up yet today in argument. I think you've addressed it in the briefs.
I think it briefly was mentioned in argument.
Okay.
And so just to highlight here, I understand that there's kind of there's a lot of federal case law that was cited in the briefs on this issue, but the Georgia version of rule of lenity, where we see it applied over and over again, is that it's a rule of sentencing. So if you get convicted of 2 offenses, one provides a lesser sentence, but they're the same act or same elements, you're entitled to the lesser sentence. The Court of Appeals this year noted that the defendant in Huber, 368 Georgia Act 401, has provided no authority, and we have found none, for the proposition that the rule of lenity can subject to demur an otherwise sufficient indictment. So our position is that while there may be in the federal cases that are cited a different application of the rule of lenity, under Georgia cases, it's not a reason to dismiss the case. Motion should be denied as to these counts. It's irrelevant where or to whom the false statements were made. There's no support for this idea of immune legal pleadings. Legislative privilege only applies to legislators, and in a few situations, their staffers, and other arguments seek to add elements that are not set forth by statute, or they're simply void speaking.
All right, thank you, Mr. Wooten.
Very briefly, Judge, if you're going to have to prove something at trial, it's an element of the offense. If you don't have to prove it at trial, it's not an element of the offense. Obviously, Haley said that it is an element of the offense that you knowingly and willfully do that. They don't plead that. They have no response to that. They admit they don't plead it. The claim has to go. With regard to legislative privilege, we're not arguing legislative privilege. What we are arguing is that when somebody comes and speaks in front of the legislature, we have a separation of powers problem, because if they're speaking in front of the legislator, invited to do that, and somebody comes in and hits them for what they say in front of the legislature, that is an issue. And with regard to the rule of lenity, that's exactly what Haley was doing. Is the rule of lenity is a rule of statutory construction, and when you're looking at these statutes, you have to interpret them in a manner that would make them constitutional. If it's ambiguous, you read them against the state. And here it says you got to have these two elements. One thing that I would want to point out to Your Honor is we've seen this obviously in the Haley case and in others. In the federal context, there was a case, Rahif, that talks about criminalizing the possession of firearms by a illegal alien. And the Supreme Court, much as in Haley, came back and said, listen, you have to have both elements have to be knowing. I have to know that I possess a firearm, and I have to know that I'm illegally in this country. And those both became elements of the crimes. The United States U.S. Attorney's Office have changed their pleading requirements for that, and have done exactly what the state should have done here, which is modify the way that they plead these cases. And what they should have pled here is that said statements are knowingly and willfully within the jurisdiction. That's not there in the claim files.
All right, who do we have for impersonating an officer?
Richard Bryson. To begin with, counts 8 and 9 charge. Count 8 charges the substantive count of impersonating an officer, i.e. the electors who reportedly unlawfully, falsely held themselves out as the duly elected and qualified presidential electors. Count 9 is a conspiracy to commit impersonating a public officer, specifically referenced in count 8. Now, nowhere in the statute, 161023, does it define what a public officer is. The only definition I found applicable in the Georgia Constitution, Article 1, Section 2, Paragraph 1, it defines a public officer as a trustee or servant of the people, and thus is amenable to the people at all times. And as the Georgia Supreme Court said in Kennedy v. Carlton, the intent and purpose of this particular section of 161023 was to protect the people of the state from intimidation and other potential abuses and dangers in the hands of someone who was cloaking themselves in the authority of the state of Georgia or officers. And thus, there must be some nexus between the public office and the alleged criminal acts. In other words, not not every criminal act committed by a public officer constitutes a violation of 1610. Now, Georgia law recognizes that presidential electors perform the duties required of them by the Constitution and laws of the United States. In other words, they're not necessarily performing the duties and laws, the responsibilities that are required by the Georgia Constitution. They are acting pursuant to the U.S. Constitution. That's contained in OCGA 21-211. And indeed, as cited in our brief, U.S. Representative Caldwell remarked that, quote, the elector is a federal functionary as much as a senator or representative, and the duties of an elector, as soon as he is chosen by the state, are prescribed by the Constitution of the United States. These electors were chosen well before the election. I think it was in March or April of 2020. When they stepped up to fulfill their duties, whatever they did as their regular job, whether it was a state senator or any other public officer, when they were functioning as an elector, they were performing a federal function and exercising duties and responsibilities under the U.S. Constitution and the Electoral College. This is not a state or local government function.
And this was an argument that was addressed, or was it touched on by Judge Jones in the removal action, right? And so what do you contend was the error in that decision?
Well, the difference is, I believe, in the removal action, they said there was more to the entire case than simply what was going on as federal function. In these particular counts, we are focused in only on what they were doing as an elector and whether or not that qualified as a public officer under this criminal statute. So even you can have a situation where Judge Jones holding that it wasn't subject to removal, but that does not mean they qualify as a public officer under this criminal statute. Now, cut to the chase. The federal elector, their status as not being a Georgia public officer is analogous to a state grand juror. A state grand juror performs duties in connection with the Superior Court. They're paid for his or her time. They're serving for a designated period of time. But nonetheless, they are not a public official under this section. We cited a case of Duffy versus Ferguson, 178 Georgia 230. And so what we have here is the alleged representations all pertain to a federal function made by someone who was acting in a federal capacity, and they are not Georgia officers. Now the state cites Garrison State with the grand conclusion that this utterly defeats our argument. Now the Garrison case, what it addressed was the sufficiency of the evidence. And in that case, Garrison and his co-defendants, they went to steal dope from a house, kicked in the door, wearing masks, brandishing guns, and they yelled at federal agents. In the Garrison case, there is not a citation to 1610-23. Not a discussion of it, not a citation to it. The Garrison case does say he impersonated an officer, but when you dig a little deeper and you look at the indictment in the Garrison case, where's your honor?
Are you tendering this as part of the record?
Yes.
An exhibit?
If you look at the indictment,
What exhibit are we tendering this as?
today would be exhibit 1.
All right.
If you mark the
All right, any objection for the purposes of this hearing?
Judge, again, like our prior objection, just to relevance.
All right. Okay, it'll be admitted for the purpose of the record, for this hearing only.
So when you look at the actual indictment, the indictment that came out of Carroll County, count 8 is the impersonating an officer. Oddly enough, even that count does not cite a statute. But when you look at it, it simply says that impersonating an officer, more specifically, he falsely held himself out to be a peace officer with an intent to mislead. disposition, which is further back in that exhibit. Frankly, it doesn't clear up what statute he was actually charged with. But I will note he received a 1-year sentence, which would be consistent with a misdemeanor. And there is a misdemeanor code section that covers this, OCGA 40 Tax 6, Tax 395, which criminalizes impersonating a sheriff, a deputy sheriff, a state trooper, agent of the GBI, or an agent of the Federal Bureau of Investigation, police officer, or any other authorized law enforcement. While the opinion in Garrison v. State does not clear up that confusion one way or other, and frankly, nor does the indictment, I would suggest to the extent that the court gave any credence or precedential value to the state citation, when you look at what was actually done in that case, the most likely statute of conviction was not 161023. It was 46395. And as the, so which all tracks back to the fact that we do not have a Georgia public officer. And under the ECA, as argued by Ms. Pearson and Mr. Gillen previously today, the alternate slate of electors was convened. They acted to preserve the election challenge while the judicial challenge was pending. And so, even if they were public officers, the statute, which they were not, under the ECA, there still would not have been a conspiracy to commit an unlawful act. Because as the court noted in its ruling on the speedy trial defense, although you came to a completely different conclusion, in State v. Cohen, a general demur is appropriate when it's a conspiracy to commit a crime that in fact is not unlawful. And in this case, holding themselves out as the duly appointed and elected Republican Party electors is not in and of itself a crime. They were the Republican electors. They held themselves out as the Republican electors. And as such, they do not constitute, or even admitting every fact and allegation in counts 8 and 9, they still would be not guilty of those counts as such as a general
These defendants aren't charged with holding themselves out as Republican electors. They're charged with holding themselves out as the duly elected and qualified electors from the state of Georgia, which is a very different thing. Just to point that out at first. Again, each count alleges all the essential elements of the offense, apprises the defendant of what they must be prepared to meet at trial, provides enough detail to protect against public jeopardy. Georgia case law does not, as we pointed out in our briefs, and as the other side tried to rebut, Georgia case law does not limit 161023 to state officers. We know that from Libri versus the state, 346 Georgia at 420. In that case, there was a conviction upheld where they just impersonated a fictitious agency. So it wasn't even an actual public officer. It was a Metro Atlanta Human Trafficking Task Force that did not exist, and the Court of Appeals said that's fine. Again, Garrison, which was just talked about, but the case very clearly upholds the conviction where they, the defendant in that case, said that he is a federal agent. I mean, I'm looking at this indictment, and I believe this helps our position because if you look at count 8 of the indictment, the language exactly tracks 161023, and it says, you know, it accuses them of holding themselves or stating that they were federal agents, contrary to the laws of said state. So I'm not quite sure how Garrison hurts us, nor am I sure how the indictment in Garrison hurts us, because it shows this is an indictment that alleges something very similar to our indictment, and it was upheld. And notwithstanding that, presidential electors are clearly state officers. They're not federal officers. We talked about In re Green earlier this morning. In re Green, very old case, makes it very clear that they are state officers. They are not federal officers. there are multiple statutes, Georgia statutes, that refer to the office of presidential elector. So there is some argument that they're like grand jurors. They're not like grand jurors. It's an office. They run for office. They qualify to be on the ballot. They get paid a little bit, I think. But there's at least 1, 2, 3, 4 different statutes in the code that specifically refer to the office of presidential electors. So it's very clear that the code contemplates that they are public officers. These motions should be denied. Again, these essential elements are pled, sufficient detail to survive special demurrer. The statute is not limited to state officers. In any case, they are state officers.
Your Honor, just a couple of things. First, Mr. Wooten is incorrect. The electors are not elected representatives. The slate of electors are not necessarily senators. In fact, I think most of them are not elected officials. They're private citizens, usually those who are contributing or active in a particular political party. So the mere fact that they are an elector does not mean they are a Georgia public officer. And he's again incorrect in that the slate of electors for both parties had been selected months prior to the election. So the fact that they stood up and said, we are the Republican electors, President Trump, if he won and if the judicial contest was successful, does not convert them into a Georgia public officer as defined in that criminal statute. And again, the point in the intent of the General Assembly in passing this statute was to protect our citizens that are cloaking themselves in the authority of a Georgia public officer. Look at almost all of the cases involve police officers who take some action that's illegal in the context of their law enforcement duties, whether it's, one of the cases cited, attacking some female that they pulled over for a traffic offense. Things such as that. They are within the cloak, within the authority of their Georgia public office. State electors do not fall in that same category. They are simply designated by a particular party to stand up and cast those electoral votes if their candidate wins. They are not necessarily Georgia senators or Georgia legislatures. In fact, most of them will not. In this case, again,
All right, moving along. Forgery. And the counts 10, 11, 16, 19.
Under counts 11 and 17, and then similarly counts 10 and 16, are a conspiracy to commit forgery in the first degree in violation of Code Section 16.9, Cap 1B. The unlawful conspiracy involved making the certificate of votes of the 2020 electors, making the electoral votes, and casting those. As Ms. Pearson persuasively established earlier, the ECA does authorize and permits the alternate contingent state of electors to undertake those actions that are criminally charged in counts 11 and 17. And based on that argument alone, these counts are subject to error. Additionally, in the state's response, what the state has said is that they are only proceeding on kind of the final prong of that particular statute. And in that statute, what it criminalizes in that fifth prong is that a person commits the offense of forgery in the first degree, one with the intent to defraud. He or she makes, alters, or possesses a writing of a check. Or, and I'm quoting, gives such authority and utters or delivers such writing. A high school English teacher would blanch if I had written a statement or a sentence like that. It makes no sense. But what we have in this case is we have the contingent alternate slave electors who held themselves out to be themselves. They were selected and identified prior to the election. And they were, in fact, the Republican slave electors. They didn't hold themselves out to anything other than being that. But more importantly, for purposes of the demurrer, the statute specifically says that the forgery is creation of a writing by authority of one who did not give such authority. And one of the things we've said is that the indictment fails to identify who the person was who did not give the authority. With that omission, the indictment is subject to demurrer. Notably, the statute does not say made by one who did not have such authority. And perhaps if the statute said that, we'd be in a different position with regard to this count. But that is not what is criminalized. What is criminalized is making that writing by authority of one who did not give such authority. And so we are left to guess, and it isn't contained in the indictment, in the preceding factual averments, who failed to give us that authority. It is a gap in that charge, it is a gap in the indictment, and it subjects it to general demurrer. The state seemingly concedes that the indictment doesn't contain the required specificity when they say, well, moreover, when the alleged deficiencies in one count, it can be read by looking at all the other counts. Now, I would suggest that Mr. Wooten has selectively utilized that. We talked about count 23. He said, well, it's not, it doesn't say that in that account, but it did talk about sending in the electoral votes in December 28th in previous counts and in previous factual averments. But in this particular instance, it does not clear it up. This does not say anywhere in any of the 161 counts that were added, in any of the 41 counts charges, it does not say who did not give them that authority. And that is something that is specifically required by the statute. And the failure to include that in the charging document requires the defense basically to guess at that and subjects this charge, both of these charges, to a general demurrer. I'm sorry, to a special demurrer.
Judge, I'll try to be brief. First of all, the indictment does specify whose authority the documents were purported to have been made under. It's the presidential electors of the state of Georgia. It's right there in the indictment. They allege all the essential elements. They advise the defendant of what they must be prepared to meet, provide enough detail to protect against public jeopardy. I think this was argued in the briefs that we had to, allege forgery in one particular way, and alleging that it was made, documents made by authority of one who did not give such authority was not sufficient. That was argued in the briefs, but I think that's kind of shifted in the argument, and the defendants are acknowledging that that is a way to allege a violation of 1691, and that's the way of violating the statute that we rely on in this indictment, and that's legally sufficient. And so I'll kind of skip through examples of the other ways that it can be violated. The indictment is not required to allege that the writing was intended to defraud anyone in particular. Intent to defraud a particular person is not an element of the offense. In any case, again, read as a whole, that's appropriate for special demurrer purposes. It's very clear that these specific documents were intended to defraud the President of the United States Senate, Archivist, Georgia Secretary of State, and the Chief District Court Judge. These motions should be denied. We plead all the essential elements. Sufficient detail to survive special demurrer. Forgery statute provides at least 5 ways of committing forgery, and impersonating another person is not required. That was the argument in the briefs. Seems as though that's kind of been moved away from an argument today. intent to defraud a specific person is not an element of the offense. And that motion should be denied, Judge.
Very briefly, Judge. As I've stated before, the statute says falsely makes or alters a writing by authority of one who did not give such authority. The indictment does not say who failed to give us the authority to sign that document as the Republican electors. We were the Republican electors.
I know. All right, Mr. Rice, I think if you got something additional to add on, but I take your argument. All right. Filing false documents. We drawing straws?
We're gonna stand on our brief, I guess. Can I, 2 seconds?
Sure.
Can we go out of order?
Yeah.
Would that be okay? Can we skip to 8 while they're figuring out?
I think Rico might be a meatier one. I want to make sure that we address the discovery issues if we have to break early. So let's skip to 10. This was Mr. Sadow's motion to
Thank you.
obtain the DC material.
He's gonna go.
Yeah.
Moving on.
We'll discovery. All right, so Mr. Sadow reviewed the motion. I guess my first question for you would be a couple, actually. I think the first thing you ask is, can I ask the DC district judge for permission? And let's say that she says no, and then you say we should issue a subpoena. I'm wondering if the state even would have the ability or authority to do that over federal materials. So essentially, I guess what I'm getting at is there actually a legal remedy to have any of these documents? And if not, what then?
Well, the answer to that is yes, there is in fact a legal remedy, and I had thought you might bring that up, so if I may, I left copies sitting over there for everybody. There. Well, this is an old case in the sense of being back in 1981. It's up in the Georgia Court of Appeals. It has not been overruled. It has not been restricted in any fashion. The Supreme Court has cited it. The Supreme Court of Georgia has cited it as authority, and it makes it clear that a litigant in the position of President Trump has the ability under the compulsory process clause of the Sixth Amendment and equal provision of the Georgia Constitution to seek federal documents through a subpoena ducis tecum. That's precisely what happened in Beaufort. The state moved to quash the subpoena in Beaufort, went up to the Court of Appeals, and the Court of Appeals upheld the right of the defendant in that case to issue the subpoena to obtain the documents. Actually said that the TUI doctrine, as Your Honor would well know, doesn't apply in the state of Georgia. We don't even have to comply with TUI. All we have to do is show under Nixon that it's relevant and material to the case in the presentation of the defense or in the presentation of witnesses, and we are entitled to it. This is why I have brought it up the way I have. So, under the circumstances, and by all means, the state can take a look at it, write whatever brief it chooses to write. It won't find anything that in any way restricts this. I would issue a subpoena to both counsel for President Trump in D.C. as well as the special counsel's office for disclosure of what I want. I've been very limited on this. All I'm asking for is a list of the discovery so that we were able to determine what they have. And if they were to fight that, which of course the Justice Department might choose to do, it would come either before Your Honor for determination, or it would come, if they wanted to remove it, strangely enough, they could remove it to federal court. strange thing on this, and the reason why this is so important is, if I can't get the material and you deem it relevant and material, the remedy is dismissal of the case. And therefore, I'm trying to figure out a way to obtain the material that doesn't present that situation to the court, which is why I suggested that maybe the court could contact the judge in DC, or the prosecution here could contact the special counsel's office in DC, or I can issue the subpoena ducis tecum. And now what I can suggest to the court is why it would be necessary to do so, and I have a perfect example based on what just came out about Vice President Pence. And again, I am not suggesting that the state has a legal responsibility to obtain the documents that I'm looking for. It's not an arm of the prosecution, and I don't have evidence. I want to say I do, but I don't have evidence to show that there has been an exchange of information with the special counsel's office in DC.
Would an exchange even be enough to draw it under? Okay.
Which is why I think the court knows me well enough from our prior dealings. I'm not going to bring something to the court's attention which doesn't have a reasonable legal basis. This would simply be the state understanding the potential repercussions of not producing the documents, seeking a way to do it with a practical means. But
And you say it's Buford as the authority that says that dismissal is the ultimate outcome? Or is it within Buford?
It is. I'm on page, I think it's page, let's see, 768, which would be the third page of the case handout, at the very bottom, where it talks about what the Attorney General could do if they don't like the subpoena or don't wish to comply. It says the Attorney General might appeal any adverse judicial order to the proper form, but without a trial court demand for the evidence, we are back where we began, and without the evidence, if it is material, the defendant ought not to be tried. And that's precisely what I'm saying here. There's no doubt that the special counsel's office in the DC prosecution has relevant and material information that deals with the allegations in this case. I sent along, as the court well knows, I sent along a highlighted copy of the DC indictment. Assume that the court's had a chance to look at that. And the DC indictment in count 1, which alleges a conspiracy to defraud the United States under 18 U.S.C. 371, in paragraph 8, I'm on page 3 of the indictment, co-conspirator 1, I believe this is accurate, although there's not been a publication other than through the media in my own investigation. But I believe when you look at the indictment, there's very little doubt that who this would be. Co-conspirator number 1 is Mr. Giuliani. Co-conspirator number 2 is Mr. Eastman. Co-conspirator number 3 is Powell. Co-conspirator number 4 is Jeffrey Clark. Co-conspirator number 5 is Mr. Chesbrough, obviously all of which were indicted defendants in our case.
So the ultimate point is it seems very clear from the DC indictment that there's a good deal of overlap. Is that fair enough?
Remarkable.
All right, just at a minimum. Okay, so
I know from what's just been reported, another leak that came out of DC, that for example with Vice President Pence, that he provided notes to DC, that is to the special counsel's office, that he's made statements to the special counsel's office, all of which he's on the proposed witness list in the previous case, number 135, which would be certainly discoverable under procedures in the state, as well as would be obtainable under the subpoena. And I'm just trying to figure out a solution to do this. This is going to take some time. My guess is the Justice Department, Special Counsel's Office, is going to fight this all the way through. And as I said, Buford might suggest the case ought not to be tried. That's one way to do it. I suggest those other alternatives. If I can't get the information and it's about a witness, as in both cases, state can't call the witness. The third way is to wait until the DC case is completely over and then seek it in a different fashion. But this is a problem, and it's clearly information that, as you said, if you look at the two indictments, and I was going to just mention through comparison if you want me to do it. If not,
I think it speaks for itself, and you've highlighted the portions, and I've seen those. And if you need to enter that as an exhibit, we can.
I'll leave open the possibility of making an exhibit. But the only thing that's not essentially in the DC indictment is Coffee County. Everything else is basically a mirror image. It includes everything about Georgia.
Okay. No,
I'll tell you the other part of this is, that you had asked me previously about, there may be a double jeopardy motion that would fall from trial in DC before here because of the nature of the allegations. Now, I'm not saying that would work. I'm just saying that there may be something in the state double jeopardy statute, but that's not part of this. What I'm interested now is how do I get my hands on what's clearly relevant material information? And I'm basing it on Nixon and Buford in this case. You'll see it when you shepherdize this. It's called Dean versus the state. And Dean is at 267, 306, 1996 decision by the Georgia Supreme Court. And it basically says, Dean is being denied access to records for use in a criminal trial. However, in the allowance of the privilege to withhold evidence that is demonstrably relevant in a criminal trial would cut deeply into the guarantees of due process of law and gravely impair the basic function of the courts, citing U.S. versus Nixon and Buford versus the state, in which Buford, it says, holding that a federal regulation forbidding disclosure of departmental information must yield to a defendant's constitutional right to compulsory process. That's precisely what I'm asking.
all right. I think I understand your argument, Mr. Sadow. So I know the Buford case wasn't cited in the motion. Does the state feel prepared to respond to this today?
We can respond briefly.
Good afternoon, Your Honor.
Let's have you name for the record.
Yes, sir. Donald Wakeford for the state. Just real quickly, Your Honor, no, we're not going to provide some kind of response to a case that we just got, not suggesting it was
Sure.
any kind of...
Obviously, this is a preliminary, just kind of exploration of where we think this might lead.
So, especially because there are a lot of very grave consequences, which Mr. Sadow was mentioning. And so certainly we're not going to go articulate any kind of response to anything at this stage. But obviously, what this requires is some closer consideration. While obviously Mr. Wade is the one who speaks for the team in most regards, I will say that this investigation, as the district attorney has made clear, is independent from the investigation or any kind of case that is anywhere else regarding Defendant Trump and the other defendants at the table. So it's sort of, to the extent that it is being made our business, we intend to cooperate. But our position is quite simply that we don't have authority over the Department of Justice, and certainly not a federal judge, and that at this stage there is no role for us to play, absent an order from this court directing how we should move forward, because we don't have anything to draw upon for the service of Mr. Sadow.
I don't know if that's exactly what Mr. Sadow would be asking for, and I don't think that's something I would ever tell you to do. I think it's really just ball might be in your court as to item number one. You say, it seems to me like you're making it very clear there's been obviously no coordination, but not even any kind of line of communication or sharing of any kind between the Fulton County and the special counsel. But perhaps Mr. Sadow is suggesting that it might be worth a phone call. That's not something that I would ever order, but might be worth it. So I guess we're just flagging that, and probably the sooner we're able to find a road forward, the sooner we can get the discovery issues taken care of. I don't think there's anything really else for us to determine or decide today, but unless there's something else you wanted to add.
Well, just this notion that if they somehow do not cooperate and comply, then our case should be dismissed based upon.
I think we'd be a long way from that. I think even Mr. Sadow concedes that. I think yeah, but it's obviously something that we need to be mindful of here as we make our way through discovery and turning it over. And maybe we'll have more enlightenment if we know what the special counsel's position is on it. I don't know who they'd be more open to taking a phone call from. I don't know. But I'll wait for direction from the parties on that, because right now, the motion was to obtain access. I guess we've had a hearing as requested by the motion, and we can reconvene at another date to have an update and see where we are. And if the state wants to avail itself of position one and bring us back some more information, I guess that's their prerogative, but we don't have to.
But just for clarity's sake, the state does not plan to take any action on this unless the court is ordering us to do something. We're not on our position taking any action.
Okay. And in that case, would the state have a position of whether the court has requested an item 2 should be reaching out to the district court in D.C.? Or is this something we need to digest?
I think we have to stand mute on that because that's not our business. I think that counsel should probably start with issuing his subpoena and see how far he gets with it.
Okay. Would I think in the Buford case I'm reading here that it was the state that intervened to quash. I guess that would be something worth flagging. Again, maybe something that the state needs more time to think about. Would the state be intending to intervene and move to quash, or would be waiting to see what the Department of Justice says?
To the extent, Your Honor, that you're looking for guidance as predicated by the case that we were just handed
Right.
and that was not in the motion, I just think we
I'm really just kind of more flagging issues to think through
okay,
for the next time we convene.
understood.
All right.
If
Yes,
I
sir.
might, Your Honor, what I'd like to do in the interim, and we can obviously get back together and discuss this, but I will go ahead and prepare subpoenas, and maybe the next time we're here, depending on where we are, I would seek the court's permission to issue such subpoenas under appropriate order. I know normally we just issue subpoenas, but I don't want Department of Justice, the special counsel's office coming in and saying, but you don't have any order that says you're allowed to issue the subpoena. So I'll prepare them and then we'll go from there.
All right. And let me just flag this as well, since this would, is there an issue here where this is an extraterritorial out-of-state subpoena where you have to go through some other process?
I do not think so. I do not believe so. If the way Buford is set up, they've kind of said in that case, you may have subpoenaed the wrong person. Maybe it would have been better if you did it to the Attorney General, but you're a right to compulsory process. Now, I think what you're asking me is, do we have to do like an out-of-state witness?
Yes, that's exactly
It's
right.
not a state entity, though. There's no provision. And
Special
I
counsel's
could-
not in Georgia.
Theoretically, I could serve the U.S. Attorney's Office in the Northern District of Georgia if it went to DOJ, but then special counsel becomes a special issue because they're different in part than DOJ, although they're under federal regulations. Or I can serve my counsel up in D.C., and they can take service and say, I'm sorry, I can't turn it over. And then you could bring them in and potentially order them to disclose it because they have it. And then D.C. will, then the special counsel's office will come in and say, no, you can't disclose it. So
Okay.
I'll just get it prepared so that you at least can see it.
All
I'm
right.
not going to be any more detailed, though, than what I said. I'm not looking for the evidence. I'm just looking for a list so that we can begin the process.
Well, to that end, though, why wouldn't you be just asking for all the evidence as well, if that's the end
Then
goal?
I can't show relevance or materiality to what the specific items that I would want to have. I want to make sure that when I'm presenting it, if it doesn't have something to do with our case or witnesses in our case, I don't want it, and I don't believe I'd be entitled to it. If it has to do with witnesses like in our case, like Department of Justice officials, Vice President Pence, there was actually another thing recently, Scott Perry, Representative Perry, some of his material was unleashed or unsealed yesterday and then sealed back up again. He's a witness, 133 in our case. So I would want to make it as specific as possible so that Your Honor would be in a position to be able to say, why would you want this if it has nothing to do with our case.
All right. Okay, any last thoughts from the state or anything to add?
Nothing, Your Honor, no, I just wanted to, nothing further, Your Honor.
Okay. We'll put a pin in it for next time. All right, so my thought here to best utilize the time we have remaining is that, with apologies to Ms. Palmer and Mr. Floyd, I think we have to come back on RICO. There's just always a lot to that. I think that would be, again, as much as there was with the ECA, not something we just want to jam through. So I'm thinking we could continue with item 7, the filing false documents, the perjury count, and then the catch-all, whatever's left, and call it a day and come back on RICO.
Judge, the filing false documents brings up the most exciting portion of today, statutory construction. And recognizing how long we've been here already, I will make this as concise as possible. Section 161020.1 is filing a false document, and this turns on what the definition of a document is. 2014, the General Assembly amended the section of the statute and inserted a more expansive definition of document. There's basically a two-part definition of the word document. The first one is inscribed on a tangible medium, stored in electronic record medium, retrievable and receivable. The indictment satisfies, or the elector certificate satisfies that first part. The second part is the one that matters. Because the definition goes on to say, shall include but not be limited to liens, encumbrances, documents of title, instruments relating to security interest in or title to real or personal property, or other record statements or representations of fact, law, or now, it's beyond dispute that the first part of that definition, the first part of the second prong, liens, encumbrances, documents, title, instruments, that does all relate to security instruments. So the issue then is, does the trailing word, other records, expand the scope of this statute beyond what was previously listed? And the answer to that, Your Honor, is no. If you follow the case, the Georgia Supreme Court case of Kinslow, or the U.S. Supreme Court case of Yates versus the United States, as a matter of statutory construction.
So I'm remembering this one obviously from the order. Why does the shall include but shall not be limited to language not override? And that is a very easy way to distinguish Yates.
Because, Judge, when it says shall include but not be limited to, it is then listing everything starting with the liens and encumbrances. It is not, if it said it applies to liens, encumbrances, etc., but also additional elements, then yes, that would be fine. But the shall include but not be limited to begins the illustrative list of potential types of documents. And when you're looking at those lists, the trailing word, the final little segment of other record statements and representations, that cannot be interpreted under Yates or Kinslow to expand it beyond what the preceding was. Because when the court is construing the statute, they must give effect and meaning to all the words in the statute. And if we interpreted that other records part of the definition in the manner that the state suggests, and frankly in the manner that you ruled on the speedy trial defendants, then it swallows, subsumes everything that preceded. And we cannot interpret it, but the Georgia Supreme Court and the U.S. Supreme Court has made it clear that we cannot interpret a statute in a manner that does that. We cannot take that trailing word that basically makes everything prior to it in that illustrative list surplusage or redundant. And with the construction that you gave it in your order on speedy trial defense, that's effectively what you've done. Liens, encumbrances, etc.,
has no meaning. All they needed to say was other records. But when they said other records, they are essentially trying to catch in any permutations of those preceding terms. And frankly, when you look at the amendment, House Bill 985, it specifically says, change provisions relating to filing false liens or encumbrances against public employees, provide for a definition to expand the protection against filing of false liens or documents to all citizens, provide for exceptions, It did not explode or expand the definition of document in a way that created much broader application than what that section had been targeted to prior to 214 and targeted to after 214. And indeed, the bill itself was also titled liens and encumbrances. And it is a matter of constitutional law in the state of Georgia that you cannot pass a bill with provisions that aren't indicated in the title of the act. As the Georgia Supreme Court said in Mead Court, the purpose of the constitutional provision requiring that the act's title must alert the reader to the matters contained in its body is to protect against surprise legislation. And if this court were to interpret that other records part of the definition in the way that it did with the speedy trial defendants, then that's what we have. We have a surprise we have surprise legislation. We have surprise criminalization.
Is the case you cited on an act's title, is that a situation where because of a defective bill title that, tell me more about that case. What actual effect did that have if a bill's title was insufficient?
What it said was, similar to this, what we're trying to do in this case, the bill's title constrains, the application and effect of the statute. You cannot title something indicating one thing and then interpret the language of the statute above and beyond and great expanse of what's indicated in the title. So it's essentially words of limitation.
All right, so while you're up, why don't we do perjury as well?
Judge, that is very brief. In fact,
you just say that the state hasn't outlined why it's material.
Yeah, their allegation in the indictment count is that effectively it comes down to the statements are material to the statements. And while an indictment to survive a special demurrer doesn't need to contain a full, detailed argument and exposition of what the materiality is, it does have to include some indication of materiality. It can't just say it's material because the statements are material to themselves. And that's really what that count boils down to. That's what the state has tried to do, and that's what the argument is suggesting.
So just how would you suggest, like a hypothetical indictment would show that materiality? I mean, doesn't something speak for itself when they're saying that someone's testimony could have influenced the grand jury and that's always going to be material if the grand jury decided to believe that person's testimony?
Every false statement under oath does not constitute perjury. And under that kind of general scenario that you just painted, every false statement would constitute perjury because you could say, well, they testified before the special grand jury,
right.
They said something false.
So it's an issue of circumstances and fact.
Yes. And again, it doesn't have to be incredibly detailed, but there has to be something more than what we have in this indictment, which is the statements are material to themselves, the content of the statements. It requires more than that.
All right, Judge, hopefully I'll take us home with this. So the filing false documents counts, quickly through this. Again, each of them allege all these essential elements. They allege enough to survive a special demurrer. Documents and issues are documents. The document defines documents as, among other things, information that is inscribed on a tangible medium. As the court pointed out, the shall include but not be limited to language. Well, they do acknowledge it in their they do acknowledge this provision in the argument. It was kind of avoided in the briefing. But again, information means words, inscribed on it means written on, tangible medium is paper. These are documents. Going to the 2014 change, the General Assembly, again, specifically expanded the applicability of 1610-20.1 in 2014. But prior to 2014, the statute only criminalized filing false liens and encumbrances against public employees. It largely tracked 18 U.S.C. 1521. House Bill 985, as the defense pointed out, signed into law, made it a crime to file any false document in any public record or court of Georgia or the United States. And the 2014 amendment did add a broad definition for the word document. It means information inscribed on a tangible medium. All these other things shall not be limited to, shall include but not be limited to the liens and encumbrances. That doesn't exclude, or that doesn't limit the types of documents to just that list or things like it. It just gives examples. I can't get into the mind of the legislature, but I would imagine this is just so that kind of the original iteration of the statute kind of carried through. I don't know why they left that there, but it doesn't change the fact that any information inscribed on a tangible medium is a document. The argument about the title not matching the contents, that's with regard to the title of the bill, not the title of the statute once it's been enacted. So House Bill 985's title was, I won't read the whole thing, but a bill to be enacted, or a bill to be entitled an act to amend this section of the code to do X, Y, Z, and the bill did amend that section of the code to do X, Y, Z. So there's not an unconstitutional variance in the name of the bill and what the bill did. I think the defense is confusing the name of a bill with the name of a statute. And we know from case law that the heading, title or heading of the statute really doesn't mean anything. That comes from Marta versus McCain, 135 Georgia at 460, 1975 case. I don't even think that the titles of the statutes are created by the legislature. I think that's created by the people who put the laws into the books and then distribute them out to lawyers like us. Again, just hitting some of the other arguments, they say that there's no allegation of what was filed by whom or whether it was in a pleading or attached as an exhibit. Those are not elements of the offenses in general. And again, taking a step further, these are attempt and conspiracy to commit filing false documents, so even more so not elements of the offense, of those offenses. In any case, the indictment does specify what the document was. It was a document titled Certificate of the Votes of the 2020 electors from Georgia. It specified who did something with it. It said that Schaefer, still on Latham, placed that document into the United States mail, sent it off to the Chief Judge of the Northern District of Georgia. The defendants again attempt to add additional elements to the offense. Not an element of the offense that the false document is material to anything. Some elements of the offense that the false document is placed in the record in any particular way. Those simply aren't pleading requirements in this case. Motion as to those counts should be denied. Essential elements are pled. There's enough to survive special demur. The documents are documents. The remaining arguments seek to add elements to the offense that are just not part of the statute. Finally, the perjury argument, I'm a little bit confused by it. But again, it alleges enough to, it alleges the essential elements, it alleges enough to survive special demur. The defense says that it fails to allege materiality. The indictment specifically alleges that the false statements were material to the accused's own involvement in the December 14th, 2020 meeting of Trump presidential elected nominees in Fulton County, Georgia, and to the accused's communications with others involved in said meeting, the issues in question. So it identifies exactly why they're material. He didn't lie about what color shirt he was wearing. He lied about something that was an issue in question before the special purpose grand jury. That is sufficient to withstand demur. And also, they cited some cases concerning sufficiency of the evidence at trial. Again, as we've discussed, that's entirely different than a pleading requirement. For those reasons, Judge, you should deny these motions. I think that takes us to the end.
Maybe.
Maybe.
I think we still had there'd been a request to also address other discovery or motions issues and just other general housekeeping. So open it up to the floor on that. If anyone wants to jump up first.
Your Honor, do you want me to go to the podium, or is this, so can you hear me?
I can hear you just fine. Thank you, Mr. Sadow.
I understand that Madam Court Reporter is working as hard as she possibly can with everything that's going on here. But I'd like to see if we can figure out a way that we can assist her in potentially getting transcripts done. She's got the load that she carries is worse than anybody. And we're trying to work with her, and she's been very kind in saying to us that, she's getting around to getting them done. I'm hoping maybe we can figure out a solution that can get them done a little faster.
Well, on that point, Mr. Sadow, we've been looking into this as well. On the front end, I'll say one of the reasons that we record every word is I'm going to be rewatching this, and I would think that you could also rewatch it and hear what you need to. And if it's not an evidentiary hearing, I don't know if a transcript would be as necessary. It's just argument here. Logistically, though, we'd explored whether if there's a way to expedite transcripts. The issue was we can't outsource that. No matter how much money you offer, we can't outsource it. Ms. Smith has to do that. And in the meantime, we also have trials. We're starting one on Monday.
I
So
understand all of that. That's why I'm most concerned, for example, obviously, you're correct about everything that watching the videos and the YouTube taping. I'm most concerned about the pleas of co-defendants, because if I understand correctly, we can't get the exhibits until those exhibits are made part of the transcript. And that kind of a,
Sure.
chicken and an egg thing.
And those aren't long proceedings, and so those I will we'll see what we can do to place those at the top of the priority list. But these longer argument hearings, I wouldn't expect to see transcripts on those expedited. If there's an interlocutory that we have to start talking about, then obviously that would, I would imagine, be part of the record. We'll just have to go through that case by case. But if there's a specific aspect you're saying you absolutely need, we'll keep seeing what we can do. But I just don't think logistically it's even.
Let's stay on as far as being able to get transcripts of the co-defendants and exhibits to go with.
All right. Anyone else on that issue? Okay. All right. Opening the floor again to just anything else in general.
Judge, just one clarification on the supplemental briefs. Given that we've covered a lot of ground today, is the court willing to allow us to take up any of the matters? I mean, obviously not to be, repeating things that we've already argued, but just to supplement any of the arguments on any of those issues. We'd request that we be allowed to do that in our supplemental briefs.
So, I think the most effective way in a supplemental brief is to say something new. But if there's a point you think there's a new way to say it, have at it.
Okay, thank you,
That's
Judge.
fine.
Your Honor, hearing that difficult to Mr. Clark, since you opened the floor, I will take the opportunity to say that we will be following in Mr. Sadow's footsteps with respect to discovery of information in the hands of the federal government that we think is relevant to our defense. And we will be preparing something to reflect that shortly.
All right, so noted.
Is there any indication when the court is planning to have the RICO arguments?
Well, I was going to probably follow that up when we see everyone's schedules, which I don't think we want to pull out our calendars here. I think that's something we can take up through email. And if we can get them this month, I know the week of the 18th, it's kind of just been a catch-all hearings. I've got trial weeks next week and the week following, and then the week of the 18th is a lot of hearings. So that'd probably be where I'd start asking everyone if we can get the RICO arguments in.
What's the starting point?
The week of the 18th. And we can take it up from there on availability. Anything else? All right. Not seeing anything. Have a great weekend, everyone. Thank you.
Thank you, guys.